Satish Kota sir, ready alla?
Ready sir. In just 1 minute ಇದೆ sir. 10:30 exact. Sure. Shall we start now, sir?
Good morning. Namaste. You are in mute.
Vinay, Sridhar Prabhu sir, unmute.
Namaskara, sir.
Yes, sir. Namaste, sir. Justice Sahib join us, sir. Namaste. Shall we start now, sir? With the permission of Honorable Justice.
Good morning. Al Sahib, namaste.
Morning.
Professor
Namaste.
Principal University Law College, sir.
Thank you, Suresh.
Namaste, sir. Thank you, sir. Thanks for accepting our
Ravi.
invitation. Sir.
Hearty welcome, sir. Yes, sir.
Thank you.
Kirti, please proceed.
Yes, sir. A very good morning to one and all present here. At the outset, I would like to extend a heartfelt welcome to all the distinguished dignitaries, syndicate members, esteemed guests, law professors, faculty, students, research scholars, and others present in this virtual gathering for the National Virtual Seminar on Legal Services, a tool for access to justice. It is an event organized by University Law College and Department of Studies in Law in association with the Karnataka State Legal Services Authority. I, Kirti K, student of University Law College, Bangalore University, consider it my proud privilege to be the master of ceremony for this event. Sadiq Khan said, and I quote, "Legal aid is central to rightening wrongs and rectifying injustice." This quote indeed highlights the importance of legal services in providing justice for all. So, without further ado, I now invite Divya Shri, student of University Law College, to invoke the blessings of the Almighty with an invocation song. Over to you, Divya Shri. for that melodious recital, Divyashri. I now invite Dr. Satish Gowda N, Associate Professor, University Law College, Bangalore University, and the Coordinator of Legal Services Clinic to deliver the welcome address. Sir, I kindly request you to welcome the gathering.
Thank you, Kirti. With the permission of Honorable Principal and Honorable Justice, sir, it's my proud privilege to welcome you all to this wonderful event. Good morning to one and all. Today's chief guest, Honorable Mr. Justice B. Veerappa, sir, Judge, High Court of Karnataka and Executive Chairman, Karnataka State Legal Service Authority. Shri H. Shashidhar Shetty, sir, Member Secretary, Karnataka State Legal Service Authority. Professor Suresh V. Nadagowda, sir, Principal and Chairman, University Law College. Professor V. Sudesh, sir, former Principal, Dean and Chairman, University Law College. Professor Dr. N. Dashrath, sir, Dean, Faculty of Law. All syndicate members, academic council members of Bangalore University, other dignitaries, guests and invitees, members of teaching, faculties, participants from different parts of the country, and ladies and gentlemen. As you all know, access to justice, legal aid translate into access to justice for the poor, the marginalized, and the disadvantaged. Provided at no cost, it protects those who do not have the means to defend their rights. Legal aid to the poor and weak is the necessary for the preservation of rule of law, which is necessary for the existence of orderly society. Until and unless poor, illiterate man is not legally assisted, he is denied equality in the opportunity to seek justice. Therefore, as a step towards making the legal service serve the poor and the deprived, the judiciary through Legal Service Authority has taken active interest in providing legal aid to the needy in the recent past. In this background, the University Law College Department of Studies in Law, in association with Karnataka Legal State Authority, Bangalore, has organized national seminar in order to provide a platform for discussion of ideas pertaining to ensuring equitable access to justice for all, with special emphasis on the vulnerable groups. We have received more than 40 papers for presentation within short span of time. And in the plenary session, judges, professors, and advocates will be addressing on different topics like importance of legal aid and service, role of PL in protecting the rights of marginalized groups, grooming law students to be pro bono professionals, role of law schools in providing legal aid, and reimagining the court-based legal services. We hope that this national seminar will prove to be a lively forum for a frank discussion, and that this may be foundational step in developing a framework for legal aid and access to justice. Now it is my proud privilege to welcome all dignitaries for this virtual national seminar on legal services, a tool for access to justice. Today, we are really fortunate to have on this occasion Honorable Mr. Justice B. Veerappa, sir, Judge, High Court of Karnataka, Executive Chairman of Karnataka State Legal Services Authority, Bengaluru. Honorable Mr. Justice B. Veerappa, sir, born on 1st June 1961, studied in primary education at Government Primary School, Nagadenalli, Srinivasapura, secondary education at Government Higher Primary School, High School, and pre-university education at Government High School, Composite Junior College, Srinivasapura, Kolar, degree at Government Law College, Kolar, and LLB at Renukacharya Law College, Bengaluru. Sir started practice in High Court of Karnataka in the year of 1988 in the office of Professor M.S. Gopal, Senior Advocate at Bangalore, appointed as government pleader on 1/7/1995 and worked up to 15/9/2000, and as additional government advocate on 25/5/2005 and continued as such till 1/1/2015 by conducting various cases. Worked at a government advocate for more than 15 years in all successive governments. Ministry of Education and Social Welfare, Government of India has awarded 3 stars merit certificate for completion of the National Physical Efficiency Test seniors conducted in the year 1979 in the state of Karnataka on 16/6/1979. Sir has passed National Cadet Corps B certificate on 11/5/1985 and National Cadet Corps NCC C certificate during February 1983 under the authority of Ministry of Defence, Government of India. Sir has represented the Bengaluru City in wrestling in the year 1984-85, won first place in Kabaddi in inter-college competition during the year 1984-85. Then appointed as additional judge of High Court of Karnataka on 2nd January 2015 and permanent judge on 30th December 2016, and presently Executive Chairman of Karnataka State Legal Service Authority, Bengaluru. Sir, I, on behalf of University Law College, Bangalore City, extend a warm and cordial welcome to you for accepting our invitation and gracing the occasion to deliver inaugural address, sir.
Hearty welcome.
We are privileged to have another distinguished guest, Sri H. Shashidhar Shetty, sir, Member Secretary, Karnataka State Legal Service Authority, who has been helping, encouraging, and guiding us to organize this event. Sir, I, on behalf of University Law College, Principal, sir, and all, extend a warm welcome to you, sir. And I welcome today's resource person for plenary session, Professor Dr. C. Basuraju, sir, former Dean Chairman, Department of Citizen Law and Direct School of Law, University of Mysore. Professor Dr. C.S. Patil, sir, former Director and Dean, Faculty of Law, KSLU Hubli. Professor Dr. M.R.K. Prasad, sir, former Principal, V.M. Salgaonkar College of Law, Goa. Sridhar Prabhu, sir, Advocate, Member, Karnataka State Legal Service Authority, for gracing the occasion. We have with us T.G. Ravi, General Secretary, Bangalore, Bar Association. I welcome you all, sir. I extend a warm welcome to Professor Suresh V. Nadagowda, sir, our beloved Principal and Chairman, University Law College, who helped, supported, and guided us in organizing this event. Sir, I extend a warm and cordial welcome to you for gracing the occasion to deliver presidential address. I welcome Professor Dr. V. Sudesh, sir, former Principal, Dean, Faculty of Law, University Law College, and Professor Dr. N. Dashrath, sir, Dean, Faculty of Law, University Law College, for their constant guidance and encouragement in organizing this event and gracing the occasion. I also welcome Dr. Jyoti Vishwanath, Dr. L. Chandrakanti, Associate Professors, and our librarian, B.J. Shivkumari, Madam, to this event. We are very fortunate to have our syndicate and academic council members, deans of the faculties, and chairmen of various departments and principals of law colleges on this occasion. I welcome them all to this program. I also welcome all teaching, non-teaching staff, University Law College, Bangalore City, and private colleges, students, and research scholars who are present here on this occasion. This program would not have been a success without the presence and participation by all the participants from different parts of the country. So once again, I welcome all the participants to this important event. Special welcome to all our beloved students, especially LLB students, LLM students, and research scholars for taking part in the program and to grace this function. Once again, I wish to extend my hearty welcome to everyone who is present at this virtual event, and even for everyone for enabling us to organize this seminar. Thank you all and all.
Thank you for that warm welcome, sir. Now it's my privilege to invite Honorable Mr. Justice B. Veerappa, Executive Chairman, Karnataka State Legal Services Authority and Judge, High Court of Karnataka, to deliver the inaugural address. Sir, I kindly request you to address the gathering.
Thank you. Good morning to one and all. Professor Dr. Suresh V. Nadagowda, Principal and Chairman, Institute of Law College. S. Shashidhar Shetty, Member Secretary, Karnataka State Legal Service Authority. Professor Dr. N. Dashrath, Dean, Faculty of Law. Professor Dr. V. Sudesh, former Principal and Dean. Dr. Satish Gowda, Associate Professor and Coordinator, University of Law College, Legal Service Clinic. Sridhar Prabhu, Member of Khalsa. T.G. Ravi, Secretary, Advocates Association, Bengaluru. All the members of the syndicate, academic council, officers, faculty members, my dear students. First and foremost, I congratulate the University Law College for having selected the subject legal services, a tool for access to justice. Today's National Virtual Seminar. Right to free legal aid is a state's duty and not government shorting. Equal justice and free legal aid means justice according to law, said by my Lord Justice V.R. Krishna Iyer. The poor and illiterate should be able to approach the courts, and their ignorance and poverty should not be an impediment in the way of their obtaining justice from the courts, said by Justice, my Lord Justice P.N. Bhagavati. Access to justice in its general term means the individual access to the court or a guarantee of legal representation. In its broader sense, it has many fundamental elements such as identification, recognition of grievance, awareness, legal advice or assistance, accessibility to court or claim for relief, adjudication of grievance, and enforcement of relief. Of course, this may be an ultimate goal of a litigant public. Under the current modern egalitarian legal system, the right to access justice has two projections. One, it must be accessible to all. It must result in giving relief that are individually as well as socially just. Access to justice is very prominently embedded in the Indian Constitution, which has been subjected to many modifications and redesigns in the last 72 years of our independence. The preamble of the Constitution of India demarcates the beginning of access to justice by securing to all its citizens justice, social, economic, and political, liberty of thought, expression, belief, faith, and worship, equality of status and of opportunity, and to promote among them all fraternity, assuring the dignity of the individual and unity and integrity of the nation. The Honorable Supreme Court of India, to various dictums, identified many components of access justice under Article 21 of the Constitution of India. The apex court in the case of Anita Kushwa versus Pushpa Sudan, reported in 2016, 8 SCC 509, while expressing the essence of access justice, held A, the state must provide an effective adjudicatory mechanism. B, the mechanism so provided must be reasonably accessible in terms of distance. C, the process of adjudication must be speedy. D, the litigants' access to the adjudicatory process must be affordable. The Constitution of India is the living document and Bhagavad Gita of this nation and the basic law of this nation. Article 39, Constitution of 39A of the Constitution of India prescribes equal justice and pre-legal aid. The state shall secure that the operation of legal system promote justice on a basis of equal opportunity and shall in particular provide legal aid by suitable legislation or schemes or in another way to ensure that opportunities for securing justice are not denied to any citizen by reason of economic or other disabilities. Multi-door court house is a court of law in which facilities for ADR are provided. Alternate dispute resolution methods are mediation, arbitration, conciliation, negotiation, lok adalat are the key to this timely and cost-effective access to justice, as they involve settling disputes without litigation and come up with creative solution that a court may not legally allowed to impose. One of the most important objectives of alternative dispute resolution method is to reduce the burden of courts, as current available infrastructure of courts is not adequate enough to settle the growing number of cases for litigation within reasonable time limit. Access to justice is key to the standard of law and basic to the enjoyment of regarding fundamental human rights. It is a basic precondition to social incorporation and a basic component of well-working majority rule government. An effective justice system must be available to the entirety of its parts. Without this, the framework dangers, losing its significance. 2. And the regard of network, its services availability is about more than straightforward entry to landstone structure or getting legal advice. After every knock, all the doors fail, people approach the judiciary as the last resort. It is the only temple worshipped by every citizen of this nation, regardless of religion, caste, or place of birth. It is high time the judiciary must take utmost care to see that the temple of justice does not crack from outside, from inside, which lead to a catastrophe in the judicial justice delivery system, resulting in the failure of public confidence in the system. We must remember that the woodpeckers inside pose a larger threat than the storm outside. Advantages of mediation for legal paternity. Peace of mind. 2. Fulfillment of responsibility towards society. 3. Fulfillment of responsibility towards judiciary. 4. Publicity and money making. Anything can be brought with money, but not peace of mind. An advocate will get satisfaction and peace of mind is only when his client get quick and good justice. An officer of the court, it is responsibility of every advocate to fight for justice. Money making should be secondary objective. Mediations saves time of clients. Client is nothing but part of society. If advocate takes part in mediation positively, he can save time and money of his client as well as the court. Thereby, he can fulfill his responsibilities towards the society. Advocate has vital duty to save the time of judiciary. It is the duty of every advocate to lessen the burden of judiciary. He can fulfill the duty by guiding his client in a positive way at a mediation process. If advocate takes active part in mediation and ensure quick and cheap relief for his client, good publicity of such advocates is possible and it can bring more clients. To prove legal services, a tool for access justice, Section 12 of the Legal Services Authorities Act provides legal aid and services to poor, weaker section of society. The limit of up to 3 lakhs, every citizen of the state is entitled the legal aid. In Karnataka, there are 30 district legal services authorities, 1.9 Taluka legal services committees, 3 High Court legal services committees. We appointed panel advocates 2,926, demand advocates 470, retainer advocates 114, stipend advocates 2,094, PLVs 4,249. In a recent Pan India awareness outreach campaign, the Karnataka Legal Society conducted the programs from 2/10/2021 to 14/11/2021, and we could reach 29,736 villages in the state of Karnataka, and more than 60,700 public got the benefit awareness campaign. And last Lokadalas, year 2021, we have the Karnataka Legal Services Authority able to settle 12,77,853 cases and total compensation and total fine penalty remitted 3.404 crores and remitted 132 crores to the government, and we have saved 861 crores indirect savings to the government. This is how the Karnataka Legal Service Authority became a tool for access to justice everybody. The concept of Lok Adalas stands a unique contribution of Indian legal system to world legal jurisprudence. It is an information system of justice dispensation which has largely succeeded in providing supplementary forum to litigants for determination and settlement of disputes. From Gandhian principles by Mahatma Gandhi, it has become a major helping hand to courts and prescribed in section 89 of the Code of Civil Procedure. The Lok Adalats provide threefold benefits. 1, speedy resolution of disputes. 2, reduce cost of litigation. 3, avoiding further appeals, thereby making the perfect instrument to resolve heightened burden on judiciary dispensal cases. In the year 2020-21, alone, about 57 lakh cases were disposed of in National Lok Adalat, which include about 31 lakhs pending cases and 26 litigation cases. Thereby, legal service become a tool for access justice and rendering excessive litigation. The role of law students in legal aid clinics basically serve the purpose of providing legal advice, not for the aim of earning profit, but in general public interest. In law schools, knowledge of law is thoroughly imparted. However, theoretical knowledge is not sufficient when its applicability is not known. Opportunities for mooting are also limited. Students pursuing the law have zeal and enthusiasm to provide legal services. Legal aid clinics thus serve twofold purpose, namely, they provide pre-legal service to economically weaker people. 2, they direct the energies of the students of law in contributing to society. The members of the legal aid clinic are engaged in spreading legal awareness in rural areas through street plays as well as legal aid camps, where they make the target population aware of different legal services programs and guide them to avail these facilities. One of the functions of the legal aid clinic is to bridge a gap between legal service authority of the government and the common people who are ignorant of the law. Legal aid clinics are not just critical in spreading the reach of justice, but they can also play an important role in advancing the practical aspect of legal education while studying law colleges. It is indeed a fact that India practical education is rare, and most of the learning academic year is by attending lecture about the concept of laws. Students normally get chance to use their knowledge practically during internship, but that is like a peeking through a window when it should be walked out of the door. This leaves most students unprepared to know the real life when they finally graduated from their colleges. Participation in legal aid clinics will expose the students to real life expertise about the application of law in real life. This legal training, that is law clinic, is a paramount importance to the students as well as the society. This can be achieved to a substantial extent of participation in their time at their colleges. One of the biggest issues of the legal aid clinics face is a lack of motivation by students to engage in the affairs of the clinic. The mega camps focus on the demand side of empowering the poor and marginalized to be aware of their rights, demand justice, while at the same time address the supply side of supporting key justice delivery institutions in providing in providing improved services to the poor through their stakeholders have rolled out a pilot programs on legal awarenesses, capacity building of intermediates, including and assisted by vulnerable groups in assessing legal services. Leakages are being developed with the other relevant government ministries, departments to reach out the marginalized people through legal literacy programs. The aim of these initiatives is to ensure effective, innovative delivery of the justice which contributes to growth and poverty reduction in the country. The results have been encouraging. Victim compensation scheme, access to judicial recourse, but also the availability of other accessible, affordable, timely and effective means of redress or remedy. The Legal Service Authority so far has played a major role in achieving access to justice for all. Thank you, one and all. Jai Hind, Jai Karnataka.
Thank you, sir. Thank you very much, sir, for your valuable address.
Thank you for those insightful words, sir. We are indeed privileged and fortunate to have you on this occasion. Now, I would like to invite Professor Dr. V. Sudhesh, former Principal and Dean, University Law College, Bangalore University, to speak a few words on this occasion. Sir, I kindly request you to address the gathering.
Sir, please unmute, sir. Yes, sir.
Thank you. My pranams to Honorable Mr. Justice B. Veerappa, Judge High Court of Karnataka and Executive Chairman, Karnataka State Legal Services Authorities Act, Sri H. Shashidhar Shetty, Member Secretary, Karnataka State Legal Services Authorities Act, the President of today's function, Professor Dr. Suresh V. Nadgowda, Principal and Chairman, University Law College, the Dean of the Faculty of Law, Professor Dr. N. Dashrath, all the resource persons, especially present here today to deliver to speak in the plenary session, advocate friends, the General Secretary of the Advocate Association Bangalore, our student alumni, Sri T.G. Ravi, and all members of the Bangalore University Syndicate, my dear students, paper presenters. Indeed, it's a very happy occasion that we have listened to the inaugural address of Honorable Justice B. Veerappa, a very humanistic judge, a very well-spoken, outspoken judge of the High Court of Karnataka. Well, my time is limited only to 5 minutes. I will not take much time, but I have 4 pertinent points to make on the aspect of access to justice. First of all, I see aspect of access to justice as an aspect of fulfillment of the preambular promise that we, the people of India, made on 26th January 1950 to secure to all its citizens justice which is social, justice which is economic, justice which is political. All of us would agree that political justice we have achieved to some extent with one man, one vote, one value. From the grassroots to the parliament, we have fulfilled these ambitions. However, insofar as the social and economic justice are concerned, the social and economic inequalities need to be much fulfilled. And in this regard, I see 2 aspects of justice. One is procedural aspects and the substantive aspect. Insofar as procedural aspects are concerned, the constitutional provisions under Article 32, under Article 226, the public interest litigations that have been developed in India by the Supreme Court, various legislations, very specifically, the Legal Services Authorities Act have fulfilled the procedural aspects of access to justice. Insofar as substantive justice are concerned, plethora of judicial decisions right from 1982 onwards, we have found that the Supreme Court of India has, in various cases of abuse of human rights, has fulfilled the access of justice in its substantive aspect, be it the protection of the rights of the under trial prisoners, be it the case of custodial torture, be it the case of environmental protection, be it the case of sexual harassment, be it the case of construction workers, migrant workers. Likewise, we find that insofar as procedure and substantive aspect are concerned, access to justice has been to some extent fulfilled. The other aspect I would like to mention here is taking a cue from what Honorable Justice B. Veerappa said, that law students need to commit themselves to give free legal aid. And it should not be, in my humble opinion, though I was principal, I am still a teacher, professor there. What we find is the culture of legal aid is limited to one semester of one particular year. I think the law students need to be proactive and follow models, whether it is in Goa or in Delhi, to have a legal aid program throughout their 5 years or 3 years of stay in the college. They need to be proactive in the sense that they must voluntarily, with the guidance of teachers, professors, advocates, and the judges in the High Court of Karnataka, must compulsorily visit as a part of their academic exercises. Last but not the least, I would like to submit on this occasion that the law professionals who have studied, who have promised to render service to the society, be it the individual litigation lawyers or the corporate firms, need to proactively involve, need to join hands with the Legal Services Authority to fulfill the mandate of legal aid. Why I'm stressing on this is in the past 2 years, the pandemic has shown how vulnerable, despite all the constitutional mandate, despite all the procedural aspects of fulfillment of legal aid, we found that the domestic workers, the migrant workers, the construction workers, all were helpless during this 1.5 or 2 years of pandemic. I find that legal aid would be more effective when we cater to the needs of these marginalized groups. We hear news about human trafficking, be it in the Northeast, in Assam or other places, or be it in Karnataka, we find bonded labor, child labor. These are the people to whom a proactive approach of access to justice is the need of the day. With these few words, I thank the organizers, especially the coordinator of this program today, Dr. N. Satish Goda, for giving me an opportunity. Thank you so much.
Thank you for those valuable words, sir. I now invite Professor Dr. N. Dashrath, Dean Faculty of Law, University Law College, Bangalore University, to address the gathering. Sir, I kindly request you to take over.
My Lord Justice B. Veerappa, sir, respected Member Secretary of the Karnataka State Legal Service Authority, Sri Shashidhar Prasad, sir, respected members of the Syndicate Academic Council, respected T.G. Ravi, General Secretary, Advocates Bar Association, respected Sridhar Prabhu, Senior Advocate and Member Kalsa, respected Professor Suresh V. Nadgaur, Principal and Chairman, respected special invitees for the plenary session, senior professors, respected University Law College and Department of Studies in Law, Legal Service Clinic Coordinator, Dr. N. Satish Gowda, my colleagues in the department, Associate Professors, Dr. Jyoti Vishwanath, Dr. L. Chandrakanti, Librarian, Madam B. Shivkumari, principals of various law colleges, advocate friends, student friends, ladies and gentlemen. At the outset, I admire and appreciate the role of the Executive Committee and the High Court Legal Service Committee of our Honorable High Court of Karnataka, and also the Karnataka State Legal Service Authority for doing a commendable job in providing access to justice to the masses of the people of this great state, Karnataka. Ladies and gentlemen, there has been a shift from family to panchayat, and from panchayat to the formally established institution through the Constitution of India by enacting the Legal Service Authorities Act 1987, amended time to time, which has been able to serve as an excellent tool for providing access to justice to the people listed under the provisions of the Act, Section 12. My Lord Justice, I stand corrected if I am wrong. Nearly 75 to 80% of the litigation is between the state and the citizen. Having said this, I feel it is very appropriate that Parliament inserted an amendment to the Legal Service Authorities Act by adding a new chapter 6A for establishing permanent Lok Adalats, where thereby we have been organizing land adalats, water adalats, power and energy adalats, and various types of adalats. My humble attention is to draw to this great institution for providing access to justice to lay emphasis upon organizing these types of adalats so as to reduce the litigation, petty litigations, which are there to the water, power, land, etc. And secondly, if I am right, may I present that the family, which is a very basic unit of the society, has to now realize its role again to see that as much as practicable, the disputes amongst the family are resolved amicably and make every family a peaceful family and happy family in society. I have been hearing that the cases relating to family disputes in the family courts in the city of Bangalore have been mounting. And the role of the mediation center situated there has been commendable in reducing such type of disputes. So therefore, I say the families have to realize their responsibilities, their role, their future perspectives towards the family, their children, their parents, their elders, and all, to see that disputes in family doesn't arise in society. I'm extremely happy that we have a legal service clinic in our college. And out of my 13 years of experience in organizing legal awareness and legal literacy camps, by organizing the Anganwadi Karyakartas, primary school teachers, I chose them because I felt they are very near to the society and they could serve as ambassadors for access to justice in rural areas. But then I felt in course of my experience that it is a very spontaneous, perpetual exercise needed to see that the access to justice reach to the masses of the people in this country. I am aware that most of our judges at the subordinate level have been kept busy by the high courts to see that they to contribute in a way, going to villages and do surveys and solve the problems there and then and there and provide justice to the rural area. I'm extremely thankful to be the part of this function, the national seminar, and I thank Principal Professor Suresh V. Nadagowda, my entire team of colleagues, and wish you all a very, very happy success to this national seminar. Jai Hind, Jai Karnataka. Thank you.
Okay.
Thank you for those remarkable words, sir. Now, I would like to invite Professor Dr. Suresh V. Nadagaudar, Principal and Chairman, University Law College, Bangalore University, to deliver the presidential address. Sir, I kindly request you to address the gathering.
Thank you, Kirti. Ellarigu namaskara. The chief guest of this inaugural program, Honorable Justice B. Veerappa sir, who is known for his eminence, landmark judgments as a judge of the Honorable High Court of Karnataka, who is also the chairman of Karnataka Legal Service Authority, Sri H. Shashidhar Shetty, Member Secretary, Karnataka State Legal Services Authority, my esteemed colleagues, Professor Dashrath, Professor V. Sudesh, coordinator of the program, Dr. N. Satish Gowda, and other members of the faculty, Dr. Jyoti Vishnath, Dr. Chandrakanti, Dr. Kumari, honorable members of the Syndicate, Academic Council, deans of the faculty, members of the bar, General Secretary Sri T.G. Ravi, President and members of the Alumni Association of University Law College, the resource persons who are kind enough to grace the inaugural program, Professor C. Basavaraju, Professor C.S. Patil, Professor M.S.R.K. Prasad, Sri Sridhar Prabhu, and all the invitees, participants, and dear students. Honorable Justice Veerappa sir has explained in detail about the requirement of legal services, particularly for the vulnerable section of people and the people who have been deprived of access to justice because of social and economic barriers. Honorable Justice has explained to us the contributions made for evolution of the law for providing of free legal aid by Honorable Justice Krishna Iyer, Justice P.N. Bhagwati. Also, he has explained the role of Legal Services Authority in rendering justice to the poor and needy, particularly by settling disputes through the process of alternative dispute resolution. As Honorable Justice has stated that Karnataka Legal Services Authorities have facilitated settlement of almost 12.5 lakh of cases, and thereby they have been able to, as per some estimate, save about 861 crores of cost in the litigation. And as per my information, we must compliment Karnataka State Legal Services Authority and the Honorable Executive Chairman, Honorable Justice B. Veerappa sir, as well as the Member Secretary Sri Shashidhar Shetty, that the Karnataka State has facilitated for the highest number of cases through the process of alternative dispute resolution system. And in fact, we are grateful to you, sir, for extending all your support and cooperation to University Law College, as University Law College have been the first college in Karnataka to immediately establish legal services clinic after receiving a direction from Karnataka Legal Services Authority. And in fact, we have appointed the coordinator and also constituted a legal services committee. And we had one program by inviting the member secretary, Cesar Shetty, who had addressed our students to enlighten them about the importance, significance, and need and necessity of legal aid services for the poor and needy. And this is the second program which we are organizing with Karnataka State Legal Services. Also adopted 5 villages to provide free legal aid. And in fact, we had to start our activities, but by then, because of this pandemic, there was a lockdown declared, and since it has been lifted very recently, and now in the coming month we are having our semester and examinations, and we'll soon after completion of exams, we'll involve our students, the 4th and final year students, paralegal volunteers. We have listed around 150 paralegal volunteers who have come actively involved in legal aid and legal literacy program. And I wholeheartedly thank you, sir, on behalf of University Law College, Bangalore University, and all our faculty for all your help and support for this program, and also gracing this program and encouraging all of us. Thank you very much. We also have our esteemed colleagues, Dr. V. Sudesh, who also addressed the gathering, explaining the constitutional values embodied in the preamble of the Constitution and need for realization of those constitutional values provided under the Constitution and other parts of the Constitution, Article Part 4, Part 3, and Part 4 of the Constitution. So in fact, I'm really thankful to Professor Videsh for all his support and cooperation in conducting all legal literacy and legal aid programs in our college. And another esteemed colleague, Dean Faculty of Law, Dr. N. Dashrath, who has also explained about the usefulness of the legal services made available to the poor and needy at various levels, as Honorable Justice has informed us that the legal services authorities have been established at various levels, taluka, district, state level, High Court legal service committees, as well as at the Supreme Court. And I'm really thankful to you also for being part of this program. And I also thank all the resource persons for accepting our invitation. And they will be addressing all our students on various aspects, the role of legal service, then the role of the law colleges in legal service authorities, and how to groom the students to involve in pro bono activities. And our dear friend and our alumni, Sri Sridhar Prabhu, he has also taken up a very valuable topic wherein he is going to address the students as to how practically the legal services are being made available to the people in the real court situation. So I thank Honorable Justice and all the dignitaries who have graced this program. And also I'm thankful to all our dear students and all the invitees and participants in this program. Thank you. Thank you very much.
Thank you for those enlightening words, sir. We have now reached the end of inaugural session. So I call upon Vaishnavi, student of University Law College, to render the vote of thanks.
Thank you, Kirti.
Over to you, Vaishnavi.
Thank you, Kirti. A warm good morning to one and all present here. I, Vaishnavi of second year BA LLB, consider it to be my profound privilege to render the vote of thanks for such a judicious event. Ranging from the legal luminaries to budding law minds, this event hosted a wide horizons of people, Hardly like to thank Justice Veerappa sir for his observant insights that enrich the thinking of many. Taking this opportunity, I'd like to express my sincere gratitude for all the distinguished judges, beginning from Honorable Justice B. Veerappa sir, Judge, High Court of Karnataka, Shashidhar Sati sir, Member Secretary, Karnataka State Legal Service Authority, Professor Dr. Suresh V. Nadagaudar, Principal and Chairman, University Law College, Department of Studies in Law, Bangalore University. Professor Dr. V. Sudesh, former Principal, Chairman and Dean, University Law College, Department of Studies in Law, Bangalore University. Professor Dr. M. Dashrath, Dean Faculty of Law, University Law College, Department of Studies in Law, Bangalore University. Dr. Satish Gowda M., Associate Professor and Coordinator, University Law College, Legal Service.
China.
Dr. Jyoti Vishwanath, Associate Professor, University Law College, Dr. Chandrakanti L., Associate Professor, University Law College, for their august presence. And at last, I'd like to thank all the participants for demonstrating their intent and zeal by taking part in this event. Now, we will have the panel discussion, which shall be hosted by my friend and senior, Arslan. Thank you all.
Thank you, Vaishnavi.
Thank you, sir. Thank you very much, sir.
Thank you, sir. Namaste, sir. Thank you.
Thank you, Justice, sir.
ಶುರು ಮಾಡಿ.
Yes, sir. Thank you, Vaishnavi. And thank you, everyone.
So now we can proceed to plenary session.
Yes, sir. Most definitely.
All the speakers have joined.
Yeah. I think we are on time. 11:30 correct again.
Yes, sir.
Yeah,
Yes,
yeah.
sir.
Yeah.
Okay.
Because we want to listen to all eminent resource persons, especially Professor Sridhar Prabhu idare, Basraj sir idare, CL, all experience. So I thought we must limit our this thing. All right. Okay. Let's begin.
Yeah, yeah.
Hope all resource persons have joined.
ಅಲ್ಲ ಇವರು CS ಪಾಟೀಲ್ ಮತ್ತೆ ಪ್ರಸಾದ್ ಅವರು ಜಾಯಿನ್ ಆಗಿದ್ದಾರೆ.
Okay,
CS
good. Sir
Patil
idare, Basraj sir idaralla.
ಮಾಡ್ತಾ ಇದ್ದಾರೆ, ಜಾಯ್ನ್ ಆಯ್ತಾರೆ. CS.
You can unmute. Arslan ಯಾರಿದ್ದಾರೆ? ಶ್ರೀಧರ್ ಪ್ರಭು ಸರ್ಗೆ, ಬಸವರಾಜ್ ಸರ್ಗೆ ಎಲ್ಲರಿಗೂ ಅನ್ಮ್ಯೂಟ್ ಮಾಡ್ಬಿಡಿ.
Oh, sir.
Co-host ಮಾಡಿ.
Post ಮಾಡಿ.
ನಮ್ ಸೆಷನ್ ಇದ್ದಾಗ ನಾವು ಜಾಯಿನ್ ಆಗಬಹುದು ಅನ್ಸುತ್ತೆ. I don't think we need to be unmuted now.
Yes, sir.
Shashidhar
Dhruv,
Shetty,
I
sir.
request you to kindly please check the resource persons as they join in.
Yes, everyone have joined it, and I've made them co-host also.
MRK Prasad sir, welcome sir.
Yeah.
Good
morning to everyone. Can you hear me?
Yes sir, yes sir. Co-host ಮಾಡಿ ಸರ್.
Yes, sir.
ಶಶಿಧರ್ ಶೆಟ್ಟಿ ಸರ್ ಜಾಯ್ನ್ ಆಗಿದ್ದಾರೆ. ಈಗ CS ಪಾಟೀಲ್ ಸರ್ ಜಾಯ್ನ್ ಆಗ್ತಾರೆ.
Sir, with your permission, may I begin, or shall we wait for sir?
ಒಂದು ನಿಮಿಷ, ಪಾಟೀಲ್ ಸರ್ ಫೋನ್ ಮಾಡ್ತೀನಿ. ಔಟ್.
Yes, sir. Most definitely.
Prasad sir, namaste. How are you, sir?
Fine, sir. How are you?
Yeah, yes, sir. Thank you. Baswaraj sir, namaste.
ಸರ್ ಬಸವರಾಜ್ ಸರ್ ಅನ್ಮ್ಯೂಟ್ ಮಾಡ್ಕೊಳ್ಳಿ. ಅನ್ಮ್ಯೂಟ್ ಮಾಡಿ ಸರ್. ಎಸ್ ಸರ್.
Good morning, Professor Nadagowda ji. Good morning.
CS Patil sir,
ಜಾಯ್ನ್ ಆಯ್ತಾ ಇದಾರೆ. ಇನ್ನೇನು ಆದ್ರು.
ಹೌದಾ?
ಈಗ ಜಸ್ಟ್
Professor Basraj sir, ನಮಸ್ಕಾರ.
Namaste. Good morning.
Professor
morning.
Prasad sir.
Oh, sir.
Hey.
Good morning, sir. Prasad sir. Good morning.
Sir, good morning, sir.
Good
How are you,
morning.
sir?
Good morning.
Yeah, fine, sir. Professor Prasad, ನಮಸ್ಕಾರ.
ಶಶಿಧರ್ ಶೆಟ್ಟಿ ಸರ್ ಜಾಯ್ನ್ ಆದ್ರು. ನಮಸ್ತೆ ಸರ್.
Shashidhar, sir. Good morning.
ನಮಸ್ತೆ ಸರ್, ಶಶಿಧರ್ ಸರ್.
ನಮಸ್ತೆ.
Excellent. Patil
Satish,
sir, join Adra. Patil sir.
it's okay. We can start with Sister sir.
ಶುರು ಮಾಡಿ
Yes, sir.
Yeah,
Yes, sir.
others will join.
11:30
Yeah,
ಇನ್ನು
go
1 minute ಇತ್ತು ಸರ್. 11:20
Yeah,
ಅದಕ್ಕೆ
yes,
just
yeah.
Yes.
waiting for exact on time. 11:30. ಶುರು ಮಾಡಿ ಅರ್ಸ್ಲನ್.
Yes, sir. Thank you, sir. Injustice anywhere is a threat to justice everywhere by Martin Luther King Jr. A warm and hearty welcome to everyone present here. On behalf of ULC, I, Arsalan Zaidi, first year LLM student, shall be the masters of ceremony for today's plenary session. We are truly grateful and delighted to have with us a judge, an advocate, and academicians, the trifecta of legal excellence, as resource persons to deliver their lectures for today's one-day national seminar on legal services, a tool to access to justice. Today we have with us Shri H. Shashidhar Shetty sir, welcome sir. Professor Dr. C. Basavaraju sir, welcome sir. Professor Dr. C. S. Patil sir, welcome sir. Professor Dr. M. R. K. Prasad, welcome sir. Shri Shashidhar Prabhu sir, welcome sir. And I also like to welcome all the other dignitaries present here. I request all participants to post any questions or queries to me through direct chat of Zoom, which shall be taken up at the end of all the lectures during the interaction session, depending on the paucity of time. Now, without much delay, let us introduce our first speaker, Shri H. Shashidhar Shetty, District Judge and Member Secretary, Karnataka State Legal Service Authority. Sir will be enlightening us on the topic of importance of legal aid and services. Sir, I request you to address the participants. Over to you, sir.
Good morning to all. First of all, I must congratulate University Law College for organizing this seminar. Very important and very meaningful one. We have been associated. Karnataka State Legal Service Authority is in association with the Law University, and we are doing many programs. And I hope and trust that it will continue forever. Coming to the today's topic given to me, that is importance of legal aid and services are concerned. I must say the important role of legal service authority in providing legal aid and services to the common man. And in that background, I will start. Access to justice to all is mantra of legal service authority. Justice Vernon of US Supreme Court said, nothing rankles more in human heart than a brooding sense of injustice. 70% of our people are living in rural area and they are illiterate. More than that population, people are not aware of their legal right. It is the absence of legal awareness which leads to exploitation and deprivation of right and benefits to the poor people. That is why, as you all, as already the many speakers have cited, and our Honorable Justice B. Virappa also mentioned about it, Article 39A of the Constitution makes it clear that free legal aid to the poor and weaker section of the society and promote justice on the basis of equal opportunity. In that background, and also the directions of the Honorable Supreme Court, starting from P.N. Bhagwati and Justice V.R. Krishna Iyer, the persistent request as well direction of the Honorable Supreme Court, the Government of India enacted the Legal Service Authority Act 1987. The said act is enacted with an object to constitute the legal service authorities at various levels, at national, state, district, and taluk level, to provide free and competent legal services to the poor and weaker section of the society, so that access to justice should be given to the marginalized section of the society, more particularly the rural people who are actually deprived of their right to have access to justice. Even today, if you go to the rural area, it is a common practice that any person, not based on his economical strata, but also a person who is living in a rural area or a villager, it is not easy for him to go to court, engage an advocate, and agitate his claim before the court. Even though he has got money, even though he has got other resources, it is not easy for him to contact an advocate. Even contacting an advocate takes a month time. And then through somebody else, he has to approach his advocate, and then he has to file a suit or a case before the court of law. That is the realistic approach situation in the rural area. The Legal Service Authority Act, which came into effect from 9/11/1985, which we celebrate as National Legal Services Day, is an important enactment which confers a very important right to have free access to the justice. The word legal services is a very wide definition. It includes any services in conducting the proceedings before any court or tribunal or authority, and any kind of legal service or aid. Then the question would be, who are entitled to get legal aid? Is it free for all? No, Section 12 of the Legal Service Authority makes it clear that the certain categories of the people who are mentioned therein are entitled for free legal aid. They are the members of the scheduled caste and scheduled tribe, victims of human trafficking, women and children, the disabled persons, the industrial workmen, victims of natural or human disasters, a person who is in jail or a prisoner, and any person whose annual income is below 3 lakh, irrespective of caste, religion, and class. These are all the persons who are entitled for free legal aid. In fact, till November 2020, the financial criteria was 1 lakh in Karnataka. Now it has been enhanced at the request of the Legal Service Authority. Government has enhanced it to 3 lakh. So these are all the persons who are entitled for free legal aid. Then how does they get a legal aid? What is the mechanism which we follow, or which the people should know? Is that the legal aid is provided not only in Taluka court, but up to the Supreme Court. As His Lordship mentioned, in Karnataka, we have got 30 district legal service authority and 114 in Taluka legal service committees. And any person who wants to file a case or defend a case filed against him, and who has come to this the categories mentioned in Section 12 of the Legal Service Authority Act, can approach the nearest legal service authority, and these legal service authority will be in the court premises. In Taluka court, Taluka Legal Service Committee will be in the Taluka court, and the district legal service authority will be in the district court complex. So he can approach the nearest legal service authority and seek for file an application, and that will be examined by the member secretary therein. And if it is there are prima facie case, then immediately an advocate from the panel of that legal service authority or the committee, as the case may be, will be appointed to file a case on behalf of the legal aid seeker. The payment of court fee, the payment towards the fee of the advocate, other miscellaneous expenses will be borne by the legal service authority. So the party who has been provided this legal aid, free legal aid, need not spend a single pie for conducting the case before the court of law. And this right of getting the legal aid is not only available in Taluka court, it may be before the district court or high court or even in the Supreme Court. So at all levels, the free legal aid will be provided. The aims and object of the Legal Service Authority Act, in brief, I have to mention it. The first and foremost is creating the legal awareness. As I mentioned just in the beginning of my talk, that 70% of the people residing in the rural area are illiterate. They do not know what is their right, which they can agitate before the court of law. So it is the duty of the state and the legal service authority to create legal awareness in all corners of the state. That's why recently we had a pan-India awareness campaign throughout the country. And as His Lordship mentioned, in Karnataka, we reached all 29,736 villages, not once, but twice and thrice in few villages. So we attempted to create awareness amongst the people. The reason of having such 45 days campaign from 2nd October to 14th November 2021 is that initially we were of the opinion that the people would reach, the people who is interested to file a case or who is really in need of legal aid would reach and approach our legal service authority. But it is not happening. Or it's very, very less case. When the statistical information are gathered, out of the pending total pending cases, only 1% of the people, the litigants are getting the legal aid. That doesn't mean that people are not entitled or not eligible to get free legal aid. That clearly shows the people doesn't know that they have got right to have free legal aid. So that is the main object of creating legal awareness. For people, we should make awareness, create awareness, and understand the people that they have got right to get free legal aid through the legal service authority at all levels, and they need not pay anything for that. The second one is providing free legal aid. As I said, creating awareness when the people approach the legal service authority or even the legal service clinic. We have established more than 1,000 legal service clinic throughout the state, in a CDP office, in a jail clinic, and police stations and other governmental offices, where our panel advocates and paralegal volunteers will be there. They are trained. So any people can approach them and get the legal services or legal advice or assistance, and who are all eligible, they will be directed to the nearest legal service authority to get the legal aid. The other one is the organizing Lok Adalat. It is an alternative dispute resolution system like mediation, arbitration, and it is very successful in Karnataka. And we are proud to say that in the last year, we could dispose of more than 12 lakhs in 4 national Lok Adalats. Apart from the regular Lok Adalats, this national Lok Adalat was a huge success. So people are very much keen to dispose of their cases. We could dispose of more than 12,000 partition suits, more than 30,000 LHAT cases, more than 22,000 MUC cases in these lokadalas, in 4 lokadalas. So it is a grand success according to me. So people now understand that it is very, very, very useful for them, because if in adjudicated system, there is an appeal provision. So once you get then a judgment from the trial court, you have to approach the appellate court and get the file an appeal. So there is a never-ending matter. But in Lok Adalat, there ends the matter. Once an award is passed, neither party to that award can approach or file a appeal before the appellate forum. Moreover, we have got 11 NASA schemes. These schemes are relating to the poor and weaker section of society, like women and children, the traffic victims, tribal people, acid attack victims, mentally ill and disabled persons, tribal people. So these are all the important schemes. For the first time in Karnataka, Honorable Chief Judges and Honorable Executive Chairman of Khalsa requested and designated 10 former judges of the Karnataka to head these committees and guide Khalsa for effective implementation of these schemes. And it is going on very effectively in Karnataka state. So, and these 10 former judges are doing this pro bono service, and we are having constant meetings with the state level officers and all the stakeholders, and passing resolutions and requesting them to reach the poor person or the needy persons or the beneficiary of the scheme to get the benefits of the government schemes. Otherwise, you know, though there are so many schemes of the government, it will not reach the people. So it will be only in the records of the government. So our endeavor is to see that this scheme of the government reaches to each and every beneficiary who are residing in the remote corner of the state. In this regard, we are also holding legal services camps. Recently, we had 3-4 such camps, and very, very effective. So there we called all the stakeholders, including the various departments of government, asked them to give publicity out to the schemes of the government and create awareness among the people so that people can understand what is their right. Otherwise, the schemes which are formulated or floated with the intention of helping the poor people will not be fulfilled. So that's how the Legal Service Authority is doing that. And also the Legal Service Clinic in law colleges. In 139 colleges now, legal service clinics are established, and it is a very important step in the progress of the Legal Service Authority in assisting the general public. The law students who are student PLVs are very much interested in joining their hands in the Legal Service Authority activities. It is a positive sign, because we can inculcate the service motto in the young minds of these law colleges students, and definitely it would be good for the future of those students also, because what the students understand and learn in the college may be the theoretical subjects, but the practical knowledge will get only when they go to the rural area. That's why we requested all the colleges to adopt at least 5 villages and make the students to go to those villages, and also we get requested to establish one clinic in such village, in the remote village, so that the people can approach the PLV students or the student PLVs who will be there in the legal service clinic established by the college. And we also requested to conduct the camps in the such villages, at least a week camp in each village where the students should go to door-to-door survey and collect this statistical data about the pending cases, pre-litigation cases, the cases which not yet reach the court, but there is a litigation or dispute in the family or in the between the people. So if those and also the other citizen-centric issues, maybe Aadhaar card, pension, mentally ill persons, medical facility, etc., etc. There are so many issues, right? So if these issues are tabled or listed, and then in the final 2 days of that camp, we have to call the local authorities, maybe the revenue authority, RTO, police, etc., etc., and we have to solve the problems of the people then and there itself in the final days of that camp. So that is our idea, and we have requested all the colleges to do that. And it is a very, very important, and the ultimate goal is to make such villages as litigation-free villages. So that should be our motto, that should be our idea, and we have to do that. And it can be done only with the assistance of law colleges and more particularly the student paralegal volunteers who are the students of the college. And as rightly pointed out by Sudhish sir, this should not be the restricted to the final year student. We should take the first year, start from the first year students only. They can also join as student PLVs. So they will have more time to understand, because the understanding the whole, the idea of legal service authority and the activities, it will take time. So 1 year, it is not sufficient to do all this. So please, I request all the colleges to join, permit the first year students or at least the second year students to join this legal service clinic as student paralegal volunteers, and let them work there. And the goal, the ultimate goal of the Legal Service Authority Act can be achieved if we can do that. Then also, the Legal Service Authority is very much interested in filing the public interest litigations. We are partly in more than 20 to 25 public interest litigations filed before the court. So these are all the cases which are going on, and I cannot now, since time restriction is there, I can't disclose or describe each and one of the litigations pending before the High Court. Then very importantly, the jail clinics. In all prisons in Karnataka, there are 51 prisons, 9 central prisons, and we have constituted or established legal service clinic, and we are sending our paralegal volunteers as well, the panel advocates, and convicted convicted prisoners whose track record is very good. After collecting the information from the prison authority, we select them as convicted PLVs, the paralegal volunteers in the jail who will work in the jail clinic. It is also very important. They are educating the co-prisoners. It is also very important one, and we are doing that, and it is successful actually, so that any prisoner, he should not be left undefended before the court of law. So as soon as a prisoner is admitted in the jail, immediately he will be informed that Legal Service Authority under Section 12, he is eligible to get free legal aid. So immediately the Legal Service Authority will provide legal services to him by appointing an advocate, not only before the trial court, before the Honorable Supreme Court, High Court and Supreme Court also. So this is being going on. And actually, during the pandemic, there was a direction by the Supreme Court that for the decongestion of the prisons in India. So during that time, the executive chairman of the High Court, who is heading the high powered committee, had directed all the district DLSS to have meetings and constituted district level committees headed by the principal district judge. And during the COVID-19 period, we could release more than 2,492 prisoners, that is under trial prisoners as well CTPs. Convicted prisoners are released on parole and under trial prisoners were released on bail. So it was a huge success actually. Now in Karnataka, almost all prisons are on moderate strength of the sanction strength. Actually, it is below 100%. So it is a very good sign, and the COVID-19 issue did not affect the prisoners in jail. So then during COVID-19, we had coordinated with the many departments and tried to help in distributing the food kit and vaccination to senior citizens and the construction workers. Then we helped in to the migrant workers, and also getting pension by the senior citizens and disabled persons, Anganwadi children and lactating mothers. So these are all the areas where we try to assist. So the providing legal services to all people who are in the society, that is our motto, and that is we are doing. So the providing legal services and aid is a very important object and goal of Legal Services Authority. And I request all the stakeholders to make it more general for all the people to understand that Legal Services Authority is there. So any person who is in need of any service, any kind of service pertain to the legal aspect is concerned, they can approach the Legal Services Authority, nearest Legal Services Authority, or they can also call to our toll-free number 1800-425-90900. So 24/7, our advocates, panel advocates, we appointed 3 panel advocates around the clock, and they are attending the calls from the general public, and they are being given advice how to go about. So this is how we are doing, and definitely we look forward and try to help more people. So all those I must request all the colleges and students make it a point that create more awareness to the people, bring more people to our Legal Services Authority so that we can help them, because still many people are not aware that Legal Services Authority is there, and it will come to our help. So you have to join hands with the Legal Services Authority, and let us together work hard and help the poor and the weaker section of the society. Thank you one and all.
Thank you, sir, for that impactful lecture. Live as if you were to die tomorrow, learn as if you were to live forever, by Mahatma Gandhi. Who better to envisage these statements than an academician? Our next speaker is an academician of vast knowledge, Professor Dr. C. Basavaraju. Sir has discharged his duties in various capacities, such as Dean and Chairperson, DOS in Law and Director, School of Law, University of Mysore, Registrar, Syndicate Member, Academic Council Member, University of Mysore. He has made his contributions in the field of law through publishing 74 research papers in both national and international academic journals. He has published 4 books, which are more significant for the legal profession and academia. He has presented 86 research papers at both national and international seminar conferences. He has produced 10 PhD candidates. Besides, he has also guided more than 150 LLM students for writing dissertations on various legal issues. He has also adjudicated more than 40 PhD theses of various universities in India. Sir will be enlightening us on the topic, role of PIL in protecting the rights of marginalized groups. Sir, I request you to address the participants. Over to you, sir.
Sir, please unmute, sir. Yes, sir.
Good morning to one and all. Respected our member secretary of Karnataka State Legal Service Authority, Sridhar Shetty sir, and the inauguration made by our Honorable Justice Veerappa sir. And today's in the panel of discussion, we have Sridhar Prabhu, advocate and member, Karnataka State Legal Authority. We have former principal, VM Zalgaonkar College of Law, Professor Dr. M.R.K. Prasad. Our former director and dean, Faculty of Law, KSLU, and my colleague, Professor Dr. C.S. Patil. And the organizers of this program, Professor Nadgowda, Professor Sudesh, Professor Satish Gowda, and his team. And basically, I congratulate the Department of Law, University of Bangalore, University College, as well as the Karnataka State Legal Service Authority for having conducting this kind of a program at the national level, especially in the virtual mode, to inculcate the basic knowledge of legal awareness to the vulnerable sections of the society. I have been entrusted with the responsibility to speak on the role of public interest litigation, ensuring access to vulnerable groups. When we say that vulnerable groups, we are always pointing towards the women, children, victims, scheduled castes and scheduled tribes, and others who are deprived of justice as a result of penury, poverty, ignorance, illiteracy. And therefore, the preambular objectives of the Constitution of India is to ensure access to justice to all. And especially, justice should go down to the common sections of the society. People who can afford to have justice can enter the pedestal of judiciary and get their problems resolved. But millions and millions of people in this country, they are not able to enter the pedestal of judiciary because of their utter poverty, ignorance, and illiteracy. And therefore, we are just our Honorable Justice, V.R. Krishna Iyer, he says in number of decisions, the constitutional goals and mandates of justice, liberty, equality, and fraternity should not be only in the Constitution book. It should reach the marginalized sections of the society. The constitutional goals should reach the poorer sections of the society. And therefore, Justice Krishna Iyer, Justice Bhagavati, and Justice Chandrachud, they have evolved a very vibrant mechanism called public interest litigation. As you know that earlier, people who suffered legal injury, they were not able to get justice because of penury and poverty. And those who have received the legal injury alone should have gone to the courts for redressal of their grievances. As a result, what happened? Many people who are unable to approach the court for redressal of their grievances, they could not approach. And as such, they were deprived of justice. But today, we have alternative mechanisms. Judiciary has become vibrant. And the judicial institution, in fact, has come forward not only in providing various mechanisms, but also providing various alternative institutions to see that justice should reach to every sections of the society, irrespective of the religion, irrespective of the caste, irrespective of the economic condition, irrespective of the social status of the society. So therefore, public interest litigation is a strong weapon in the hands of poorer sections of the society. It ensures people's participation in the administrative process. Earlier, what happened was, in the administrative process, there was no possibility of common people to participate. And as a result of which, whatever the decision taken by the administrative authorities, certain sections of the people, they had to accept it, as there was no public participation of these people. So therefore, there is a need to protect the interest of the vulnerable sections of the society. Why I am stressing the vulnerable sections of the society means, justice is really being denied, and justice is really being deprived to the vulnerable sections of the society only, because they cannot afford to engage a lawyer. They cannot afford to enter the pedestal of the judiciary. So therefore, the old concept of, or the traditional concept of locus standi, which required the injured persons to approach the court for redressal of their grievances, has been completely liberalized. And it was very much required also for this Indian system, and where millions and millions of people, the poor people, they are living with utter poverty. And as our former speakers, our Honorable Justice Veerappa sir said, 70% of the population of this country, they are not aware of their basic rights, their basic constitutional mandates. And therefore, for them, the constitutional protection, the constitutional mandate of equality, liberty, justice should not be a distant dream. It has been repeatedly said by many honorable justices in various case laws. So therefore, there is a need to ensure justice to all kinds of vulnerable sections of the society. The mechanisms are different. It could be through the public interest litigation. It could be through the legal service authorities constituted under the Act. And it may be through conducting various legal aid programs, legal aid camps, surveying the problems of the people across the state or across the taluk or across the country. So therefore, there has to be a mechanism, a strong mechanism, to see that the marginalized groups or the vulnerable sections, they should not left without having access to justice. Having access to justice is a fundamental right of every citizen of this country, irrespective of their religion, irrespective of the status, or irrespective of their economic condition. Just because a person is not able to approach the court, that does not mean, or it should not be in such a way that they should be deprived of the justice. Otherwise, the very objective of the preamble is defeated, or the very objective of the establishment of the judiciary under the Constitution of India is defeated. So therefore, there are various areas in which we need to ensure justice to all through the mechanism of public interest litigation. For example, there is a need to protect environment. As we know that as the growth of the industrialization, as the growth of the urbanization, even in the rural areas, we are not getting good environment. Everywhere there is a pollution of air, pollution of environment. People are not aware. Majority of the rural people, they are not aware about the pollution of environment and its effect on their health. So there is an obligation on the part of the state as well as every citizen of this country to see that even those rural people who are affected by the pollution of environment, pollution of water, pollution of air, they should be protected. How to protect? We have to conduct awareness program. We have to make them aware about the effect of pollution of environment. So therefore, through public interest litigation, it is possible to ensure the pollution-free environment to all people, irrespective of their status or irrespective of their religion. So therefore, even the field of medical field, or where there is a requirement of medical assistance, we need to protect the interest of every individual in terms of health. Their health is very important. Today, in many villages, we find that people are suffering from lack of nutritious food, malnutrition. And therefore, their growth is not proper. They are not living in a hygienic condition. Their health condition is very worst. How to set right and how to ensure a proper health or proper healthcare services to all these people? Healthcare services can also be provided through legal aid services. By recognizing the problem of these people who are living in various rural areas, deprived of the health services, should also be identified by our students of law. If they have any problems, health problems, and where health services are not properly provided by the state or properly provided by the particular authority, then there is a need to look into these issues by our students of law. How the students of law can go for it? Many times what happens, it is not possible to set right by going from home to home. We can use this public interest litigation. Today, there are many associations and organizations have come into existence. Many associations, organizations have come into existence to take the cause of the poorer sections of the society. And we are fortunate that the Indian Constitution has provided a fundamental right to form association and form unions and form organizations as a fundamental right. Through these organizations, through these associations, through these trade unions, we can file the public interest litigation and to see that whatever is due for the vulnerable sections of the society should reach in order to achieve the constitutional mandate mentioned in the preamble. Even in respect of the problems relating to laborers, there are plethora of decisions given by the Supreme Court. How public interest litigation has helped to save and to protect the interest of the labor class. In many industries, in many mining operations, there are thousands and thousands of workers. They are working by the deprivation of their basic requirements. And there are a number of decisions given by the Supreme Court directing the appropriate governments, appropriate authorities to see that the interest of the laborers, the interest of the workers working in various institutions or organizations, or even the industries, industrial undertakings should be protected. It is possible only because of the public interest litigation. Today, we cannot expect every citizen of this country to file a formal petition because of economic instability, because of their poverty. And I always remember what Justice Bhagavati said, our Honorable Justice Bhagavati said, the constitutional fundamental rights which are guaranteed should not be only in the textbooks. It should be brought to implementation through various mechanisms. And one such mechanism is public interest litigation. It is unfortunate that even after the evolution of this concept of public interest litigation, by liberalizing the traditional concept of locus standi, there is no effective use of public interest litigation mechanism for ensuring justice to the vulnerable sections. Today, now the legal service authorities has come forward to take up individual cases, to take up the genuine cases of the vulnerable sections. It could be women or children. It could be scheduled castes and scheduled tribes. It could be victims of various crime, incidents, victims of human trafficking. And they have come forward to take the cases directly and to resolve them through various mechanisms. It could be adalat, through adalats, lok adalats, or it could be in any manner, or by adopting the alternative dispute resolution mechanisms like negotiations and all that. See, whatever may be the mechanism, whether it is through the public interest litigation, whether through the lok adalat, or whether through negotiations, mediations, and conciliations, or whatever may be the mechanism, ultimately, what is required is justice should reach the common sections of the society. Justice should reach the targeted sections of the society. There must be access to justice to all, irrespective of their status or irrespective of their conditions. And today, to whom justice is required? Justice is required for those who are unable to get justice in the court of law or in the legal institutions. So therefore, there is a need to ensure justice to one and all through mechanisms like public interest litigation or through legal service authorities. I have seen that much of the public interest litigation mechanism is used in order to protect the interest of especially the prisoners, the problem of prisoners. In addition to the tribals and the scheduled castes and scheduled tribes and women and children, much of this mechanism is used by the various public organizations and public spirited persons having public bono for saving the interest of the prisoners. For example, we know that how public interest litigation through which the right against handcuffing has been recognized by the judiciary. How through public interest litigation, right to have speedy trial has been identified by the Supreme Court. And through the public interest litigation, how custodial deaths, right against custodial death has been recognized by the Supreme Court. And ultimately, through public interest litigation, how right to have free legal aid services has been established or recognized. See, therefore, this mechanism of public interest litigation has entrenched or it has extended its tentacles to various fields. It is not only the field of medicine, field of labor, or the problems relating to women and children, scheduled castes and scheduled tribes. It has extended its tentacles to all the areas. And today we are very happy that the public interest litigation mechanism has grown like anything. It has grown to such an extent that through public interest litigation, the rights of the vulnerable sections, the interest of the vulnerable sections, marginalized sections now can be protected. Otherwise, these people would have been left free without having access to justice. And that is not the constitutional mandate, constitutional objective. The fundamental objective of the Constitution enshrined in the preamble is to ensure justice, both social, economic, and political justice. Even after 70 years of the Constitution came into force, have we achieved the social and economic justice even through this public interest litigation? So therefore, these are all the major issues which we need to focus upon, and how to make the mechanism of public interest litigation still more vibrant in order to achieve our preambular objectives of the Constitution. And of course, our speaker, Honorable Justice Veerappa sir, as well as our Shashidhar Shetty, our Honorable Judge, also said the importance of this, the Karnataka State Legal Service Authorities. And of course, it is going to the grassroots level of the people. And with the help of the students of law, I would say it is not only the law students. We should involve all the students of different disciplines, to see that they should also be, in fact, inculcated the basic knowledge on the law, so that they can also go to the various fields, various places, to meet various people who are really suffering from some legal issues. For example, it could be legal issues, could be like the child marriage, or sati system, or even the problems relating to the scheduled caste and scheduled tribes, where still there is a discrimination is going on. See, all these social evils which still exist in the society can be regulated through our sincere effort in using the public interest litigation. Because ordinary people cannot approach the court. People who are really having some bona fide intention, some real intention to ensure justice, can approach the court through public interest litigation. Even for public interest litigation also, there is no need to go directly to the court and make a formal application, not necessary. There is an epistolary jurisdiction. The court has identified the epistolary jurisdiction. You can write a letter to the appropriate authority in the courts, either to the Supreme Court or High Court, or you can send a message, or you can bring to the knowledge of the registrar of the High Court or Supreme Court, and your letter or information will be converted into a regular writ petition under Article 32 or 226 of the Constitution. See, these are all the things which needs to be inculcated to our students, inculcated to our publics, so that they should also have some awareness to how to use the public interest litigations. But one thing is certain: public interest litigation weapon should be used only to ensure with public interest to have access to the vulnerable sections. But in the garb of public interest litigation, there shall not be any private interest. That is to say, there shall not be any misuse or abuse of the mechanism of public interest litigation. Our former Justice Krishna Iyer, Justice Chandrachud, Justice Bhagavati, they evolved this doctrine of public interest litigation with an object. The objective is to ensure justice to vulnerable sections of the society, marginalized sections of the society, because they should not be deprived of the constitutional rights, because constitutional rights are given to all, not only to the haves but also have-nots, not only to the rich but also to the poor sections of the society. So therefore, this kind of public interest litigation, the role of public interest litigation in ensuring to ensure access to justice to all, in fact, has become an integral part of the fundamental right to life. In the Indian Constitution, we speak about right to life. Today, I would say that access to justice is access to life. If access to justice is ensured by the through public interest litigation or through legal aid services, it is as much as an access to life under Article 21 of the Indian Constitution. And therefore, every citizen of this country and every legal institution has certain constitutional duty to ensure access to justice to all, and especially for the marginalized groups. And I hope that the role of Karnataka State Legal Service Authority is of paramount importance, and its role is commendable. Over the period of time, we have been seeing that thousands and thousands cases are in fact disposed of through Lok Adalat, and thousands and thousands of cases are brought to the knowledge of the legal service authorities. It is because of the sincere effort. And therefore, these types of mechanisms of public interest litigation or the legal aid services authorities, sincere efforts have made every citizen of this country to have access to justice, which is due for them. And I'm sure that this national seminar, having discussion on all these various issues to provide access to justice, in fact, really it ensures some confidence with the vulnerable sections of the society, weaker sections of the society, and to see that they should also live with human dignity. They should also enjoy the constitutional rights, and they should also live just equal to that of the other societies. And after all, what is the fundamental objective of ensuring having access to justice? To see that the society should be kept balanced. People who are imbalanced in the society should be made balanced. They should be made par with that with the rest of the society. And therefore, we should ensure fraternity. Constitutional objective is to ensure fraternity and equality. And of course, therefore, this kind of a program, national seminar on the role of legal services to the society, and also through various mechanisms through which the services can be can reach the targeted sections of the society, in fact, is of paramount importance. And I congratulate the organizers for having given me an opportunity to just share a few thoughts about the role of public interest litigations, ensuring access to marginalized groups. Thank you.
Thank you, sir.
Thank you, sir, for that marvelous lecture. We are what we repeatedly do. Excellence then is not an act, but a habit, by Aristotle. Our next speaker is a personification of excellence himself, Professor Dr. C.S. Patil. Sir has discharged his responsibilities as Dean, member of Syndicate and Academic Council of KSLU, and Director of KSLU's Law School for 7 years. Sir has written on books, edited 2 books, and more than 80 articles in law journals. He is one of the experts to submit a research paper to the Committee on Reforms of Criminal Justice System, of which Honorable Dr. Justice V.S. Malimat was the chairperson. He has drafted many legislations for the government of Karnataka, including Karnataka State Human Rights Court Rules 2006. He received a commendation for his work in the field of human rights in 2010. He is a member of the expert committee for establishing of Karnataka Rural Development and Panchayat Raj University. Professor envisages a lot of interest in curricular, co-curricular, and extracurricular activities, and has been involved in legal aid and legal literacy activities for more than 20 years. Sir will be enlightening us on the topic, grooming law students to be pro bono professionals. Sir, I request you to kindly address the participants. Over to you, sir.
Thank you very much, Mr. Arsalan Zaidi, for that nice introduction. Honorable Judge Shashidhar Shetty, H, Member Secretary, Karnataka State Legal Services Authority. My good friend and co-panelist, Professor Dr. C. Basavaraju, former Dean, Registrar, various capacities in Mysore University, Acting Vice Chancellor. My dear colleague, Professor M.R.K. Prasad, whose association I have always enjoyed, academic and extra-academic. My good, young, and very dynamic friend, Sridhar Prabhu, who has played some instrumental role in systematizing the legal aid activities in the Karnataka State Law University, 107 colleges. Professor Suresh Nadgaud, the dynamic faculty member, equally dynamic Professor Sudesh V, Professor Dashrath, my dear young friends, Dr. Satish Gowda and Dr. Mallaya, who is member on the Khalsa, and all the wonderful invitees on the platform, the learned faculty members of the University College of Law, and I see other faculty members and principals of colleges who are here on the platform, and Arsalan Zaidi, a polished student who is coordinating this activity, cordially, courteously approaching us for various things, and all dear friends. I join everyone in congratulating the organizers, both Khalsa and the Bangalore University, for choosing this theme, legal services, a tool for access to justice. If legal services are to be treated as a tool for access to justice, we need leaders who will take this tool and provide access to justice to the needy people. We want agents of these legal services. We want crusaders of these legal services. Both lawyers and law students have to play this role of being the stewards of access to justice. For that reason, I have chosen this topic, how we have to groom the students in the law schools and colleges so that they will become these stewards, the knights who will hold the cudgels of reaching the chariot of reaching the legal services to the vulnerable people, needy people. You see, this grooming is very, very important. In law schools and colleges, we should not train tigers who will behave like hired guns, who will fight for the people who pay for the services. We want people who are professionals in the real sense of it. And in the colleges, we have to groom the students to understand what is a profession and what is their responsibility when they become professionals, and what is the nobility that is laced into these professions historically all through the world. If I understand what I am, then I will understand what my responsibilities are. And then only I can discharge my responsibilities in a befitting manner. It is stated all professions are noble. Why all professions are noble? They are noble because they are knowledge-based. Professions are knowledge-based. And because they are knowledge-based, society does not want to control these professionals. They have conferred professional autonomy on the professional, saying that you are the knowledgeable people and you regulate yourselves. And the journey of the development of profession has gone through various stages, from chaos to organization, from organization to consolidation, from consolidation to autonomy and monopoly, and now we have to speak of accountability of professionals. Just enjoying autonomy is not, it is not a luxury that is conferred on the professions, and this luxury of being autonomous is conferred with something in return, that is pro bono publico commitment on the part of the professionals, that element of accountability of the professionals. So now the movement is towards accountability. And Of all the professions, legal profession occupies a place of pride. Why legal profession occupies a place of pride amongst the gallery or galaxy of professions? Because no other profession has to shoulder so much of responsibility as the legal profession. Other professions shoulder limited responsibility, whereas legal profession shoulders the responsibility of condemning injustice and tyranny in any form. When I am a professional, I should condemn injustice. When I stand as a lawyer, it is not just my priority to protect the interest of my clients. It is my responsibility, a professional responsibility, which is more than my responsibility towards the client, that is responsibility of condemning injustice, and we have to train students for this. The United Nations Basic Principles on Role of Lawyers, published in 1990. My dear friends, we have to appreciate this fact that the United Nations has published what are basic principles on the role of lawyers. And therein it is noted that the professions must possess independence and they should be self-governing in nature. Bar has a crucial role to play in democratic countries. This is what UN says. Bar has a crucial role to play in democracies. If we are a battery of lawyers in this independent India, which is democratic, we have greater responsibility in a democracy, and this is as per the UN mandate. That independent role requires, see, we say law is an independent profession. Other professions are not independent professions. We have to appreciate what is an autonomous profession and what is an independent profession. Law is an independent profession. Why it is an independent profession? Because the profession of law requires lawyers to oppose the government in defense of their clients' legal interests. Lawyers' independence from political branches of government is important to rule of law. See, law should survive as an independent profession. This is very important for a democracy. This is very important for survival of rule of law, and lawyers should not be controlled by the government. This is the meaning of law being an independent profession. When the country is passed through bad times, whether it is independence struggle, whether it is emergency situations, to refer to our own country, what happens? The bar and its members will be at their best to save the rule of law. And this is evident in different parts of the world, and India is not an exception. Whenever the country is at crossroads, the bar stands up. Bar speaks against tyranny. Bar speaks against the repressive government. And the truth is, ordinary people in these crisis situations will be looking at what lawyers do. And they look at what lawyers do and they will follow the lawyers. That's how lawyers are the leaders of the society. The great author Krishna Swami Iyer, Professional Ethics book, he makes a statement. He writes like this: destroy the bar and you will destroy the bulwark of civil and criminal justice. Nay, you will destroy the very foundation of security and liberty. A government of law is the supreme manifestation of civilization. And as Lord Bacon said, law is the great organ through which the sovereign power of society moves. So if you destroy the bar, the whole system, the bulwark of liberty and rule of law will be destroyed. This is Krishna Swami Iyer. So this bar, the profession, has a role to play which is greater than just appearing before the court for the clients. there is a greater role as contemplated here. Sir John Davis, he places legal profession higher than medical profession. Why he places legal profession higher than medical profession? Because all men at the same time do not need doctors, or any person will not need a doctor all the times. They stand in need of physicians whenever there are issues with the health. But all men at all times, in all places, do stand in need of justice and of law, which is the rule of justice, and of interpreters and administrators of law, which give life and motion unto justice. This is a very important statement. All men at all places, at all times, need lawyers, because these are the people who are the agents of justice and who are the interpreters of justice, and who will put that motion of justice into action. That's why autonomy is conferred. There should be commitment on the part of the lawyers, and this commitment should be infused into the student. It should be infused into the blood of every student who is going to be lawyer next. Why autonomy is conferred? What is the raison d'etre for professional autonomy? Roscoe's definition in his work, Lawyers from Antiquity to Modern Times. Roscoe says, there is much more in a profession than a traditionally dignified calling. The term refers to a group of men pursuing a learned art as a common calling in the spirit of public service. My dear friends, you have to underline this. Here you have a group of men pursuing a learned art as a common calling in the spirit of public service. No less a public service, because it may incidentally be a means of livelihood. Pursuit of learned art in the spirit of public service is the primary purpose of every profession. That is the primary purpose. And Justice Brandeis of American Supreme Court, the same Brandeis of the fame of Brandeis brief. And Justice Brandeis, he attributes 3 criteria to a profession. If something is to be a profession, 3 criteria. First, profession is an occupation for which the necessary preliminary training is intellectual in character, involving knowledge and to some extent learning, as distinguished from mere skill. So knowledge is at the root of professions. Second, this is very important for our context. Profession is an occupation which is pursued largely for others and not merely for oneself. This is the pro bono publico commitment of the profession. It is an occupation which is pursued largely for others and not for oneself. It is an occupation in which the amount of financial returns is not the accepted measure of success. That's why, in a rhythmic manner, Honorable Justice V.R. Krishna, in that famous Davolkar's case, has said about the bar like this: the bar is not a private guild like that of barbers, butchers, and candlestick makers, but by bold constraint, a public institution committed to public justice and pro bono publico service. If these are the high expectations of what is described as a noble profession, its members must set an example of conduct worthy of emulation. So bar is not a private guild like that of barbers, butchers, and candlestick makers, but by bold contrast, a public institution committed to public justice and pro bono publico service. The professionals should understand and they should know what is their commitment. As I was telling you, the quid pro quo for professional autonomy and independence can never be less than pro bono publico commitment. You are the masters, you decide, you set the standard, but what we expect from you is pro bono publico commitment. And that's what that is expected from the profession in return. And my dear friends, after coming into force of Section 30 of the Advocates Act, after 50 years of the enactment, on June 15th, 2011, the position of lawyer advocate has changed from that of an officer of the court to an advocate as a matter of right. Now, every advocate is an advocate as a matter of right, and he is not at the mercy of the courts. He can appear before any court as a matter of right because Section 30 has come into existence. When we train students in the law college, there should be a correlation between what they learn in the law college and their role in the society. This correlation we have to establish through curriculum. And any subject that is taught, any activity that is undertaken in a law school or college goes by 3 levels: the purpose, the activity, and the subject matter. The purpose is a knowledge of the roles and functions of the lawyer and of the private and public interests he may serve in performing his task. So when we train our students, we should train them to appreciate what is the private interest and what is the public interest that will be served. What is the private interest and what is the public interest that will be served by this professional undertaking any task. If we can appreciate what private interest will be served and what public interest will be served by various equations and propositions, he will understand his role. For example, while learning public law, constitutional law, administrative law, etc., we should think of social revolution that is contemplated in the Constitution, to which my good friend Basavaraj was very frequently referring. While learning public law, we should think of social revolution. We should think in terms of the controlling Constitution, the structurization of power as ordained in the Constitution, and the ultimate welfare of the common man. When we are learning criminal law, subject to the due process rights of the accused, we should appreciate vindication of social interests. We should appreciate that the paramount goal of criminal law is vindication of social interest. Rights of the accused are to be protected within the framework, but societal interest, societal well-being is of paramount importance. When we speak of corporate laws, when we speak of IPR laws, we should train students to think in terms of equity. It should not lead to concentration of wealth against the mandate of the Constitution. What is the equity? What is the equity? See, every generation stands on the shoulder of earlier generations. If somebody has invented today, patented, cooperated, etc., protection of intellectual property, gentlemen, you are intellectual because of your forefathers. Because all the knowledge that was already existing in the society, you have used, and you are looking ahead. For that, you have a limited interest, limited rate. So there should be emphasis on compulsory licensing provisions and similar provisions when we speak of corporate law and IPR law. When we speak of private law, we have to speak in terms of saving the social institutions like family and other units, so that there will be no need to bring in senior citizens protection of rights 2007 Act, wherein there will be a provision that children should respect their parents, children should give food to the parents who are not in a position to. See, this happens because we emphasize on individual rights and we are not emphasizing on social well-being and saving of the social institutions. I will take 2 more minutes. 20 minutes I have touched. Please, organizers should permit me for another 2-3 minutes to speak. I want to add one more point to this. Deadline, time is a deadline, and deadline is the line of fire, that is the line of activity, and all of us by experience know we are so active when the deadline reaches. So now I am at deadline. There is one principle known as conscientization. Conscientization. CONSCIENTIZACAO. Conscientization. Conscientization is a principle which I have freshly learned because I am rereading through a book, Pedagogy of the Oppressed. Please, whenever possible, read this book, Pedagogy of the Oppressed. And there is another sequel written by the same author, Paulo Freire, Pedagogy of Freedom. Pedagogy of the freedom, and this is Pedagogy of the Oppressed. Long back, I had read these books, and my dynamic young friend, Anjana Reddy, principal of the prestigious college in Bangalore, and he has gifted me these two books. Sir, you had read these books long back, better you read it again. When you are at the deadline, I have read it, and this comes in the preliminary pages of this book, Pedagogy of the Oppressed. Conscientization. Conscientization means to learn to perceive social, political, and economic contradictions. So whenever we study as students of law, we should perceive social, political, and economic contradictions and take action against the oppressive elements of reality. So when we study any law, we have to take into consideration the social, political, and economic contradictions that are there in the law. Whether it is intellectual property law or family law or any other law, we should try to make out what are the social, political, and economic contradictions in that law. And we are, after appreciating these contradictions, what are the elements that are oppressing the goals? And we should attack these oppressive goals. Okay. When we have to attack these oppressive goals, we should become radicals. Not in terms of terrorism and other things. Radicals in terms of idea and ideology. Okay. And we should attack these elements which are oppressive. If we are to do this, we have to move away from the conservationist attitude. We should go for change. We should not feel in terms of maintaining status quo. We should not speak in terms of, if we have to go away, we are not status quoists. But there is a problem. There is fear of freedom. This we have to accept. And as professors of law, we have fear of freedom. Freedom from fear is the prime human right. Freedom from fear is the prime human rights. But as conscious individuals, we have the fear of freedom because majority of us are status quoists and we do not want to go out of that framework. Okay, this is the problem. Fear of freedom is there. And this fear of freedom is due to feeling of maintenance of status quo. We should go away from this. For that, we should have radical ideas. We should not become sectarians. We should be radicals in terms of forgetting fear of freedom and move towards attaining this object of attacking repressive elements, which we have found out after perceiving the political, social, and economic contradictions that are there in legal provisions. With that, I call it a day. I thank everyone for the wonderful opportunity given. Thank you very much.
Thank you, sir.
Thank you, sir, for that inspiring lecture. We are almost at the end of the session with the last two speakers. We are grateful to all our resource persons for their patience. Now, justice delayed is justice denied by William E. Gladstone. This statement provides us the importance of justice and the need of legal aid. Our next speaker shall enlighten us in this regard, Professor Dr. M.R.K. Prasad. Sir is a leading expert in clinical education in India. He is the first recipient of a Vanderbilt Fulbright Scholarship. He joined V.M. Salgaonkar College of Law in the year of 1996. He is instrumental in establishing and functionalizing India's first legal aid setup being run by a law college. For this initiation, V.M. Salgaonkar College of Law received the Institutional Excellence Award 2011 from Society of Indian Legal Firms and Menon Institute of Legal Advocacy Training. He is a member to develop e-content on access to justice for University Grants Commission project.
That would be enough. You could just say I'm a professor.
Yes, sir, most definitely, sir.
So much time.
Sir will be enlightening us on the topic of role of law schools in providing legal aid. As sir has a huge biodata, we heartily welcome him, sir. Sir, it's over to you to address the participants. Thank you, sir.
Thank you, Aslin, and good afternoon to all the panel members, organizers, and the participants. I think anybody could introduce me as a professor, that's fine. Today I was asked to talk about role of law schools in providing legal aid. I would stick on to 15 minutes. Probably I may finish a little early. I know that it is almost lunchtime and there is one more speaker. First, I would just very briefly talk about what is legal aid, and we should understand what are the elements of legal aid so that we would know what the law schools are doing. And then the next part, I will talk about what is expected from the law schools. The third part, I would be talking about what law schools have achieved till now. And the last part, I would be looking at the way forward. How do we do it? Now, the first thing that comes into our mind when I say legal aid is representing a client in the court. That means essentially we are talking about litigation services. But unfortunately, legal aid is not confined to represent the clients in the court. There are three legal aid reports, which I will discuss a little later, identify at least 7 components of legal. The first one is the very obvious of the representation. The second one is legal advice. Third one is paralegal services. The fourth one is legal literacy. The fifth one is law reform. Sixth one is promoting ADR, that is alternative dispute resolution. 7 is public interest litigation. That means there are 7 services which would be counted under the legal aid. Probably the law colleges and the law students were expected to play some role in that, in improving the access. Now, what is expected from the Radhakrishna Commission in Higher Learning has advocated that both the legal education and the legal profession must contribute to the social change. That means in some way that the legal education should involve in bringing the social change. And in 1950, the landmark thing that we have achieved in this country has adopting a wonderful constitution, though adopted in 1949, but came into force in 1950. It clearly says that the constitution is adopted for the purpose of bringing socio-economic and political justice, equality of status and opportunity, freedom of thought, belief, etc. Right? So this is a very important document where the law students are time and again studying, reading, analyzing what would be their contribution in bringing this justice, liberty, and equality. The third one is the expert committee on legal aid by Justice V.R. Krishnaiyer in 1973. It talks about we need to modify the law school curriculum and focus on the citizens. We must introduce clinical legal education, and the law schools also must focus on socio-economic poverty, and law students must engage in public services while they are in law school. So this is one of the report very clearly where the Justice Krishnaiyer indicates that we need to involve the law students. And a follow-up of this in 1977, the Committee on National Judiciary, Equal Justice and Social Justice also talks about developing a cadre of clinical law teachers in the law schools and introduce legal aid related subjects in the law college. It also advocates to provide academic credit. So it also says both the law teachers and students shall be allowed to be represented the clients and legal aid program and advocated for amending the Advocates Act, which otherwise doesn't allow the law teachers to practice. Then in 1981, Justice P.N. Bhagavati legal aids report on Committee for Implementing Legal Aid Schemes clearly suggested that the legal aid clinic should be established in the law schools and the universities. And all these three reports, without any hesitation, tells us that we need to involve the law students. They are young, energetic, and of course, the word that they have used in one of the report is a cheap labor, in a sense that they could able to bring the access to justice without much financial requirements. And also they identified the ambit of their reach, because the law schools are spread and across the length and breadth of the country. They expected that this would really provide that momentum for the access to justice. So similarly, so therefore, finally in 1997, the Bar Council of India brought a circular asking all the law colleges to start. That means with one stroke in 1997, all law colleges are expected to start legal aid clinics. However, in 2008, the Bar Council rules on legal education removed legal aid as a practical subject, brought ADR into that area, and made that every law college must have a legal aid clinic where the final year students must be part of it. Okay, so these are some of the efforts that were made to involve the law colleges, expected that the law students and the law teachers would play a pivotal role in providing legal aid to bring access to justice to the needy, oppressed, and disobpressed. However, it looks nice on the paper that involving the law colleges and the law students in providing legal aid. But what is delivered? What happened with this? If you see till 1997, whatever the legal aid activities involved by the law colleges or the law teachers are mostly voluntary. And particularly, of course, if anybody read the history of law colleges, legal education, it is the Delhi University, which started first of its kind and followed by other colleges. But almost all of these are voluntary efforts made by the faculty and the students. And no academic credit, no recognition in the workload. So it is like run like an extracurricular activity for some of the law schools. However, by 1997 with the Bar Council, we have no other option but to start legal aid center, clinic, whatever you call. Therefore, at least for a namesake, the majority of the law colleges do have legal aid clinics. So therefore, in that sense, Bar Council of India had made some impact of having a legal aid cell, though in many colleges non-functional. A small room was put a title of legal aid room. But however, it has given some, what I call is and encouragement some of the law schools which are serious about doing legal aid. So the law students started engaging with the community, at least in some form. And I would say that the most of these legal aid clinics or the legal aid cells started by the law colleges, mostly focused on legal literacy programs. Because when Bar Council, most of the colleges have no clue what to do and how to do. It's because there is no guidelines or suggestions came from the Bar Council, except to say that the legal aid clinic should be introduced. And most of the teachers, I would say 98 or 99% of the teachers, not having any background of the practice in the court, purely academicians, struggled how to start a legal aid cell and what to do with them. Okay. So as a part of that, the legal literacy programs, which are an extended version of lecturing, was happily taken by these legal aid cells. However, there are few colleges have strengthened their legal aid program because now there is an academic credit was given and the teachers could be given a workload. So that's why you could see that different colleges have started the actual legal aid clinics. I could divide them into off-campus and on-campus clinics. The majority of the law colleges started on-campus clinic. That means you have one clinic in your campus and whoever visits your clinic, you would be giving advice. And some colleges, like my college, we started off-campus. That means we don't have the legal aid cell in our college campus, but we have in the community itself. That means the reach of the community is much easier to these cells where you have off-campus clinics. And it is kind of legal aid services to the doorstep. So they become more popular than the campus because one of the issue with law colleges, which I talk about in challenges, is that accessibility to the colleges is an issue. And some of the colleges also experimented with starting specialized clinics like the Child Rights Clinic, Prisoners' Rights Clinic, Consumer Clinic, the Center for Disability, Rights of the Disabled Person, Human Rights Clinic, Environmental Clinic, etc. Some colleges also started adopting a village and focusing one or two villages of all their legal aid services. And I come across at least one law school sending their students to a family mediation centers to support the mediation process. So because the Bar Council of India did not give you any structure for us, so each college started experimenting on their own, and it's kind of a boon for the colleges because it started playing to the strength of their college. And depending upon where the colleges are situated. Now, what are the challenges that we face? I very much liked Professor C.S. Patil's lecture, and he passionately argued that the law students must be encouraged to do pro bono. So he and me and a Bangalore University can say that. But if you look at most of the private universities, including the national law schools, if you see their fee structure, the high cost of legal education, nothing comes less than 2 lakhs. And I don't say anything about the pro bono when I pay the 2 lakhs into 5 years of 10 lakhs plus another 1.5 lakh to 2 lakh for my boarding. You could imagine what I would like to do. Because at the end of my course, I need to pay back the loan I have taken. This is the chicken and egg problem that the Western countries face. We successfully brought that to the legal education by privatizing it. So this one problem. The second problem which we face particularly with the legal aid cells is the accessibility to the colleges. If you see most of the traditional colleges, there is no entry barriers. But most of these private universities, national law schools and others, majority of them are not in the community, they are far away from the city. And number two, if you go there, there would be a heavily guarded security guards with a blocking of the gate as if that is some secret machine is happening in the educational institutions. Unless you write, you tell, and somebody tells, they won't allow you inside. So this is kind of an access barrier that happens to most of the colleges. Some of the colleges, like traditional colleges, do not have that barriers. Anybody can walk into your college. So therefore, running a legal aid cell becomes an issue. And most of the colleges have very half-hearted attempt. And because the teachers have no expertise in that, there is no support given by the Bar Council nor any other persons. And there is a lack of leadership. This is a serious matter in the law colleges. And particularly the principals, deans, head of the departments, directors, unless they show the leadership and give full-fledged support to the legal aid activities, legal aid becomes difficult to provide by the law schools. And another important thing, after 2008, without academic credit for the students and no workload benefit to the teachers, I still don't understand how the legal aid can be still continued. See, the legal aid, doing legal aid as a matter of passion would run for a year, 2 years, 3 years, but then you are burned out. So unless that academic and workload credit is given, it would not work. And my last point, how do you improve? Because we have some of the legal service authorities here, my sincere request and also my pleading to legal service authorities to have a meaningful collaboration with the law school clinics. Maybe this kind of a webinar is fine to have a collaboration, but that would not sufficient. What we expect, I request everybody to look into Section 4K of Legal Service Authorities Act, which says it's the obligation of the legal service authorities to develop in consultation with Bar Council of India programs for clinical legal education, promote guidance, supervise the establishment and work of legal service clinics in universities, law colleges, and other institutions. When I did a 7 states survey under the UNDP in 2011, I hardly see any legal service authorities supporting a legal aid clinic in any law college. So a meaningful collaboration is very key for the success of this legal aid cells. As simple as allow the students, legal aid clinic students, to work with your pro bono lawyers, because the legal service authorities have so many lawyers working on free legal aid cases. Allow the students, two students in each lawyer for support. They would be able to improve the quality of legal services. Like that, there are many, including your financial support and involving them. And I do understand that the legal service authorities also have structural problems, because what subjects on which you can do legal literacy and all come from the National Legal Service Authority, which is exactly a problem. For example, in Goa, if somebody want me to do women empowerment, we may not require. We may require on land laws or something else. So it depends upon the community, what the community wants you should give, not according to your expertise you want to give it to the community. The another aspect that the legal service authority could help us is these prison visits and prison clinics, because you have a dedicated lawyers visiting to the prison. The law students could be involved in drafting those applications, etc. And then the collaboration with the bench. Unfortunately, there is no involvement of the bench in legal services, legal aid services with the legal aid clinics with the law schools. That is where I look at some good collaborations. Training of the teachers, training of the students are important to teach what is legal aid. Because the moment we say legal aid, go and represent the client in the court is not the legal aid. That's not the only legal aid. A whole lot of these paralegal services representing the clients in quasi-judicial authorities like consumer forums, right to information commission, etc., is also a representation. We have a lot of opportunities. And I sincerely believe that the academic and workload credit would be given to the teachers and the students. And we need to strengthen the legal aid clinics by human resources as well as financial resources. And the last one is what we required is a motivation, commitment, and dedication from the faculty. If the faculty is dedicated, that enthusiasm will go to the students. And believe me that the students are wonderful. You need to just push them to the brink. They are going to do. That's what my experience of last 10 years running legal aid is. Thank you very much.
Thank you, sir, for that industrious lecture.
Thank you very much.
Thank you, sir.
A lawyer's time and advice are his stocks in trade, by Abraham Lincoln. At a time when legal services have become expensive and scarce to most, it's best understood by a lawyer who represents his clients who are in need of justice beyond the barriers of financial difficulties. Our final speaker for today, Sri Shashidhar Prabhu, advocate and member, Karnataka State Legal Service Authority.
Sridhar Prabhu.
Yes, sir, I'm sorry. Sri Shashidhar Sridhar Prabhu, advocate and member, Karnataka State Legal Service Authority, and is also a member of the Academic Council of Karnataka State Law University, Hubli. Sir has nearly 2 decades of practice
I
in the
think
High Court.
sufficient.
Yes, sir. Most definitely, sir.
Thank you.
Yes, sir. Sir will be enlightening us on the topic of
More-
reimagining the court.
More than that,
based-
he is our alumnus.
Yes, sir. Yes, sir. Reimagining the court-based legal system. Sir, I request you to kindly address the participants. Over to you, sir. Thank you.
Thank you, Arsalan. I would begin by thanking my alma mater, University Law College, Bangalore. Esteemed Judge Shashidhar Shetty, our leading member of the our leading light to the Karnataka State Legal Services Authority. My co-panelists, Dr. C. Basavaraju, Dr. C.S. Patil, and Dr. Prasad. Our Dr. Sudesh and Dr. Dashrath, my colleague in the Legal Services Authority, Dr. Malaya, esteemed syndicate members and academic council members of the Bangalore University, faculty members, principals, faculty members of other law colleges and other esteemed institutions, HODs, student friends, and sisters and brothers. In fact, it is indeed a privilege to me to be part of this function for 2 reasons. One, the cause is very dear to our heart. A reimagination of the court-based legal services is what we must aspire for and what we must strive towards in these COVID times, these difficult times. In fact, there is replete imagination of court-based legal services. We have an ALSA scheme. I thought of sharing the screen to show you what imagination has already gone into this aspect. In fact, when there are 3 approaches, 3 fundamental approaches to the legal services. First of all is outreach based. Outreach based is to reach the communities which are part of the NALSA schemes, which is a very popular mode of legal services. We know about Kanunu Rathas, we know about the conclaves and programs that we organize to create awareness. Then second important module is to approach through clinics or committees to these communities, not just creating awareness, but resolving their problem by reaching out to these communities at their doorstep. We have camp modules where camps have been organized at various district levels and taluka levels. We have organized camps at the tribal hutments. We have organized camps at the factory levels. Now, that is the second approach. Third most important approach is court-based legal services. Now, the first two approaches are very important, very vital, but they just lay the thematic edifice for the legal services. It is to create legal awareness or to reach out to the masses is like saying to create awareness about their hunger. Now, you take a hungry person and you say, you are so hungry. And what is hunger? How hunger is defined scientifically, legally? It increases the hunger. The hungry man will not even listen to you. He knows about the hunger. You are teaching a person who has already experienced the pain. But ultimately what matters is to resolve the problem. To borrow from Marx, he said, philosophers have interpreted the world, but the task is to change it. So we have interpreted it enough. We have understood it enough, but now the time is to act. In fact, I was told that the legal services as we know today evolved in France sometime in 1790 when the French Revolution was on its anvil, and it was conceived by many lawyers were part of this French Revolution. It was conceived that we must abolish bar. The biggest hindrance to legal aid or legal services was conceived to be the bar itself. So they abolished the bar itself in 1790. But this did not work. They, in place of lawyers, they appointed the public-spirited individuals who would give free legal aid to the people. But this did not succeed. That is why, very reluctantly, Napoleon re-established the bar, the French bar, in 1810. You see, therefore, you cannot do legal services or you cannot reach the legal services without the aid of lawyers. The lawyers are the most important, the most fundamental constituents of reaching out legal services to the masses. So therefore, the task is to empower the lawyers. In 2019, there was a study conducted by Indian Council for Social Sciences Research to study the condition of lawyers in 18 states and 32 courts to see what is their economic condition, what are their challenges in rendering the legal services. Now, it was discovered that the plight of lawyers is really abysmal. The panel advocates, the panel counsels who are the heart of the legal services movement in India is far from being satisfactory. So therefore, there were recommendations made how to enliven the lawyers, how to make the lawyers sustain in rendering the legal services. If the soldier is starved, we cannot win the war. So therefore, one is the economic sustenance of the advocates who are engaged in legal services. This is something foundational. But it does not mean that by increasing the legal fee of the lawyer, or increasing the number of panel advocates, increasing the remuneration that we pay to the legal counsel, we can achieve the objective. Of course, that is very important. But aided with that is how do we, more fundamental to that, is how do we motivate these lawyers to engage themselves in legal services. So my first suggestion, I would begin by saying, is the first way to empower the lawyers is to motivate them philosophically on the importance of legal services. See, today, we have the concept of mentor and monitoring committees being constituted at the High Court level, legal services committees, and various other district level and taluka level service committees. The mentoring committee or the monitoring committee must train, educate, enthuse, and render fillip to these advocates to make them feel proud that they are legal services counsel. So for that, we need to create training programs. The academia has a big role to play. In fact, my alma mater, University Law College, has given us this opportunity to share this thought that academic institutions and the bar councils, the bar associations must team together to create an institutional structure to train the legal services panel advocates. In fact, we have advocates academies which are training the advocates today. We have Bar Council Academy also, which is engaged in the academic exercise of training lawyers. But more importantly, the legal services authorities themselves have to create a training structure, an institutional training academy for the panel advocates to train them, enthuse them, and bring them in touch with the important constituents of the judiciary, also the academia, to know what are the various schemes, what are the various realms of law, and how effectively they can render the legal services. This is something which should be contemplated. Second, when they take up a case in the courts, the court-based legal, when they render the court-based legal services, they must be mentored by senior advocates. Today, it is not one of the conditions precedent, or I would say it is not one of the important criterions for the designation of advocates to see how much legal aid or pro bono cases they have conducted. In fact, there is some weightage given to this aspect, no doubt, but that is not a very prominent constituent of designation of advocates, senior advocates. That must be introduced. At the second level, all senior advocates, designated senior advocates of all high courts must be made part of this mentoring and monitoring committees and must be entrusted with the task of training the legal service council on the cases, on the job. In fact, when a case comes, he or she must be assigned with a senior advocate to whom she must approach and take guidance and draft and settle the drafts, conduct pleadings, formulate the pleadings, conduct trial strictly under the instructions of these senior advocates. So each advocate, panel advocate, must be given a mentor, senior advocate. Also, the academia can also play an important role by giving their support through the interns, through the academic, through the students and the academia who are working as associate professors or assistant professors can form this team. And once the case reaches an important phase of final arguments, the panel advocate must be completely empowered with the strength of the research and acumen of all this entire team. So once that happens, it will enthuse every advocate to be part of the panel advocacy of the legal services. This is something that we must think of. The second important suggestion that I have aided with that is we must think about training these advocates on client counseling itself. So what we normally, the notion that we have is that this is a free legal service. It is not free. The funding is by the state. That we must bear in mind. Nothing comes free. In fact, there is funding either through a personal funding or through the state funding. So in fact, the whole services are being funded. They are a very important exercise of the state. In fact, my Lord, Honorable Justice Chandrachud recently said, court is yet another service rendered by the state. The court system itself is a service rendered by the state. It is not an eminent domain exercise by the state. It is not to show the state's prowess, but to show how benign the state is to its citizen. So whenever a matter comes, we must train the advocates. One is the thematic part of it, the theory part of it, and the practical part of it. But more important is how to conduct yourself with the client. What questions you must ask, how you must make her or him comfortable in revealing the actual facts. You see, we have a scheme known as the NALSA scheme known as the Free and Competent Legal Services Regulations 2010. So the regulations have a format. The format is filled up. The case history is written. But this is the mechanical part of it. The human element of it is how the client what is the client counseling, and how the client must be made to reveal the entire gist of the case. So once you give the specialized training or the special training to the legal counsel, they will then be a distinguished members of the bar. They will then be profited immensely to become the effective lawyers. So one would go and say, look, I enrolled myself as a panel advocate for the legal services. Now I'm a better lawyer. I'm cut from the rest. So this proud feeling must be instilled and actually inculcated into the into these advocate fraternity who are opting for the panel advocates. Then you see, the remuneration structure for the advocates is one part, but compensating them for the out-of-pocket expenses they bear. For instance, an illiterate comes to you with a set of papers. The papers are not clear. You have to apply for RTI. You have to get the document from the court. You have to get certified copies. All this must be aided, and there are expenses, traveling expenses. You can't make the litigant all the way come every time to Bengaluru or other district places. So these out-of-pocket expenses must be the important constituent of the recompense structure. Then you see, in June 2020, NALSA published a handbook of formats for standardization of the documents for all the legal services institutions across India. So that book must be given, the academia has to, my request to the academic institution is that please try to publish those documents and make them reach widely. In fact, Bangalore University can set an example by, through its publication division, to publish books and give these books free of cost or at a very nominal cost to the legal services authority, or independently distribute them to the advocates and litigant public in a big manner. So this, the publishing part, you see, the study material that is required for the legal services advocates is something very special and something very important. Then you see, the other suggestion that I have is the role of the Bar Council and the state bar councils. As panel advocate for the Bar Council of India, I have seen the challenges faced by bar councils today, the state bar council as well as the Bar Council of India today. We have multiple roles. We have role in regulating the legal education, regulating the profession, but at the same time, we must also venture into the legal services by effectively monitoring whether the legal service committees have been constituted, legal aid clinics have been constituted in each colleges. So if it is not, then there must be a suo moto case or a suo moto proceeding to see that these things are constituted at the college level. But more important is the training of the advocates on the ground in the courts must be the primary responsibility of the state bar councils and the Bar Council of India. So specialized training modules must be initiated for the advocates. Now, finally, I would say that the court-based legal services have to receive about 80% prominence in the entire priority list of the legal services for this reason. You see, the moment you conduct, see, the outreach programs and awareness programs are important, but the district judiciary and the taluka judiciary is heavily burdened to organize these programs in the first place. We must face the harsh realities. Today, if we make a JMFC organize an outreach program comprising of say 10,000 people, 5,000 people, or even 1,000 people, where does he mobilize the resources required for it? And even if he organizes that, will his judicial work not suffer? No, will he not be answerable to the litigating public and the huge disposal of cases that he has to focus upon? So what we must ensure is that the legal services should not be a burden on the judicial institutions, particularly the presiding officers at the taluka and district levels. So therefore, the entire focus must be now shifted to the court-based legal services only. Of course, the court-based legal services will not give us publicity, will not give us the requisite reward, but the immense satisfaction that we derive by the court-based services is something incalculable. You see, you solve one person's problem, the immense satisfaction the client gets, the panel advocate gets, the legal services authority gets, and more importantly, the judge gets in resolving this dispute is something very phenomenal. And the focus on the numbers must be replaced with the quality delivery of legal services. You see, we must not be so much engrossed with how many cases we resolve, but how effectively we resolve the case. So therefore, the focus must be on the quality rather than the quantity. I'm not for a moment saying the numbers are not important. Numbers are important given the magnitude of cases that we have at our command. But the quality delivery is very important. We must treat a legal service case as important as we treat a business magnate case in a corporate litigation. So I would conclude by saying this. One is that the colleges and the academia have a very important role in inculcating the philosophy required for a lawyer to engage himself in court-based legal services. We have to groom them very young. The very first year, we must inculcate this philosophy of the fact that the case is not just a matter. It is not just a case. It is a cause for which you must fight. And there are allied advantages, disadvantages, like remuneration comes, remuneration goes. But particularly a case is a cause we must fight for, we must espouse for. One. Second, the academic institutions must train him so robustly that as a lawyer, he must be inspired to take up at least 1 or 2 pro bono cases, legal services cases per month. Then the senior advocates must be made to feel obligated that they must train their junior colleagues in taking up matters, and also they must settle drafts, they must guide them with arguments, conducting trials, and they must train them very robustly and professionally. Finally, the advocates themselves must be self-motivated and understand the rich benefit they would derive by solving by rendering the court-based legal services, and they must come out of this mindset that the funding is free, the legal aid, or it's a free thing that we are doing. No, the state is immensely funding it, and we must give equal or in fact more importance to legal services cases than the cases that come in the routine course. So with this, I would conclude. Once again, I thank my dear friend, Dr. Satish Gowda, Professor Suresh Nadagaudar, Professor Sudesh, and my team at the Legal Services Authority, Dr. Malaya, Arsalan, and my co-panelist for important inputs that you have given, sir. We would carry out this as a part of our Legal Services Authority team. We would be more than happy to team up with you in the academia, and we have richly benefited. Thanks indeed for giving me this opportunity. Thank you once again.
Thank you, sir.
Thank you, sir, for that insightful lecture.
Thank you.
With this, we have come to the end of the plenary sessions, but due to the paucity of time, it may not be possible to conduct the interactive sessions, and we apologize to all our resource persons for the same. And as a small notice to all the participants of the technical session,
can we take up one or two questions?
Okay, sir, most definitely.
We have first and last speaker. Remaining 3 speakers have left because they have a class.
Sir, if the resource persons are willing.
Sridhar
Prabhu sir is there, and Shashidhar Shetty sir is there.
Most definitely, sir.
So 1 or 2 questions can be in case if audience wish
yes,
to
sir. We
ask.
have the list, sir. If sir is willing to take up the questions, I'll be posing them right now.
Harindran?
Yes, sir.
It okay,
Sir, we have a question for you, Sridhar Prabhu, sir. That is, sir, how stable is it for a lawyer to engage pro bono cases over a long term, especially when the lawyer is a young beginner, with regards to the one which you are just speaking, sir? Yes.
You see, the intangible, I understand that it is very idealistic and very theoretical to say that the young lawyers who are at the formative phase of their career must take up the cases. Even if you ask me whether I would have been able to take up the matters at the formative phase, I am doubtful. But the immense intangible advantages that it derives is something very important. As a young lawyer, now even your normal cases are also pro bono cases. Please understand, there's no client who is ready to pay you per hour for 50,000 or 60,000 or even 5,000. Okay, a client who comes to you for an advice is not ready to pay you for that advice. He is ready to pay you for the case, maybe. But most of the legal advice that you render as a young advocate is free of cost. So you are not doing something very different or something very radically different from when you take up the legal services cases from your routine practice. It is part of your routine course. One senior advocate from Gulbarga was telling me that I am ready today to sit between Saturday 2 o'clock to 4 o'clock for the legal services authorities as a panel advocate of the legal services authority. I will not sit as a senior advocate. I'll sit in my chambers and you can send clients and give me legal. Then I jocularly asked him, sir, are you not sacrificing a great lot? No, he said, in Gulbarga and many of our North Karnataka cases, many people come and take free advice from me. I don't mind. I don't mind designating myself as a legal services authority advocate. So as young lawyers, what we must realize is the intangibles that you derive and the respect that you command from the bar and from your fraternity and from the academia is something very immense. So it is worth the bet. I am not saying this with any idealism in mind, but I'm saying it as a very pragmatic consideration that lawyers will realize this after 5 years or 10 years down your career, that how fruitful your interaction with the legal services authority has been.
Thank you, sir. We have one more question. This is an open question for both Shashidhar Shetty sir as well as for Sridhar Prabhu sir. So when can legal aid be denied and what kind of cases can a person apply for free legal aid?
I think I have already made it clear who are all entitled for free legal aid. Section 12 of the Legal Services Authority Act makes it clear. As far as service is concerned, as Sridhar Prabhu said, it is open for all. We have more than 1,200 legal service clinics throughout the state. So wherein the panel advocates and trained paralegal volunteers are there, they are providing free legal services. As far as legal aid is concerned, as it is for the categories mentioned in section 12 of the Legal Services Authority Act. So we can't generalize it. It is not for the rich people. It is only the poor and weaker and marginal sex people who are entitled for free legal aid. As I said, women and children, the scheduled caste, scheduled tribe members, the victims of trafficking, victims of disaster, natural disaster or man-made disaster, the persons who are in prison, that is UTPs, under trial prisoners or CTPs, and the industrial workmen, and any person whose annual income is below 3 lakhs. So these are all the persons who are entitled for free legal aid. And legal services are concerned, it is open for all, and we are doing that. Yes, Sridhar Prabhu, anything to add?
No, sir. I think you have summed up succinctly. I fully agree with you.
If anyone wants to ask,
and I just want to mention one thing. Mr. M.R.K. Prasad, in his talk, he has mentioned about meaningful cooperation by the Legal Services Authority. As he is right, but the thing is that it is you can't expect everything from Legal Services Authority. See, we are more than 6 crore people. But the Legal Services Authority is concerned, it is a very small segment in all districts we have. And you should know that the working style of Legal Services Authority. In the Taluka places, the Taluka Legal Services Committee is headed by a senior civil judge or a senior most judge in that Taluka and assisted by the member secretary who is also judge. And both of these judges are there in the judicial side, working in judicial side. So in addition to that, their judicial work, they are doing this Legal Services Authority activities. Likewise, in the district also, the principal district judge is the chairpersons of the district Legal Services Authority. In addition to his judicial work and other administrative work, administrative work, he has to do this or he has to discharge this legal service authority activities. So it is very, very vast area, and you can't expect a judge to devote his time only in 1 hour. He can do that. Definitely he can't, because from 10:30 to 5:30 or 5:45, he will be in the court. So what we say, we expect the legal, the other stakeholders like the law university, law colleges, the faculties, law students should involve and assist us. So workforce is the required workforce for to meet out the demands of the people is very, very, very large. But we don't have. Even the government is not ready to provide the staff. The sanction strength is 311. We are working with 30% of the sanction strength. So the staff is also very less. So these are all the problems which we face. So that's why we want to reach out to all the possible avenues. That is why we have formulated, myself and Sridhar Prabhu took initiative to this, and the Professor Ishwar Bhatt also helped us, and the other many local law universities were part of that. The standard operating procedure which we formulated and we circulated to all the law colleges, how to go about, how these legal service clinic should be established in the colleges, and how the students should be involved to carry out these legal service activities. So if it is done, because legal service clinic is established in many colleges, but it is not active. What we expect is more. So you have to reach out to the people. We can't establish a legal service clinic in namesake in one college and shut up it. No, we should reach out it. That's why we requested all the colleges to adopt at least 5 villages, any villages chosen by them, and there the activity should be carried out. That is how we can reach the people. That is how we can address the problems of the people. And conducting programs by legal service authority or doing this work by only by the legal service authority, we can't reach everybody. Definitely it is impossible. So that's why not only reaching the people, we have to bring the people to the forum, that is legal service authority, so as to provide the free legal aid to the needy people. That should be their motto. That should be the interest, that nobody should be left out who don't have the economical capacity to reach the legal service authority. Yes, Prabhu sir.
No, I have nothing else to add except that the judiciary structure, not many of us would appreciate how the judicial structure operates. You see, you have a deputy in the executive realm, you have a deputy commissioner and AC Tahsildar who report to him. There is a reporting hierarchy, and there is a formulated, a structured approach to subordination. But in a district place, a additional district judge does not report to the PDJ in an administrative manner. You see, he is also a judge, the PDJ is also a judge. Only in functional aspects there is reporting, but there is no hierarchy which defines. You cannot entrust the work. He is not subordinate in that sense. ADJ is not subordinate to PDJ, or a senior civil judge is not subordinate to the PDJ. Administratively, they are in their own realm. So this becomes exceedingly crucial for particularly the district judiciary to man these services, just like the other executive work is handled by the other executive staff. So therefore, what we must realize is we must fill in that gap as students, as academia, or as panel advocates, or as legal fraternity. We must fill in that void and become the foot soldiers of the legal services movement.
Thank you, sir. Thank you for clarifying all our doubts.
Yes, sir. Okay, Aslan, thank you. Then you can conclude the session.
Most definitely.
I have one last question. If you please allow me. Sir, I have one last question, sir. So, respected sirs, professors, and respected speakers, like while we are trying to expand the footprints of the legal services aid, now one of the challenges which we are facing is shortage of people and the number of population we have to reach out to. Now, why can't we use data science as a means of at least giving the first level of research, first level of legal aid, And so that if people come, so that way standardized responses can be framed. And if people after that they are not happy and they want some specialized responses, then they can always go to the next level. And there we can have somebody, human interaction there.
Yes, as part of that, we suggested that the books, it can be digital books or digital material, can be prepared. We have prepared. The big challenge that we are facing is to reach this to the common public. As state legal service authority or district legal services authority, we have our own limitations. These books or the material cannot be accessed by many. We have an app today. NALSA has an app on the handphone. You can have you can download the app, NALSA app. You have our channel also. A Telegram channel also is today very much available, and our website also gives a lot of information. Of course, there is a need to increase the digitization of the information that we have today, and we would be more than happy to associate ourselves with the academia in coming out with books and materials and training, the basic material, or you would say as the standardized response material for reaching out to the large sections. The publication divisions of the universities can team up with us, with the legal services authorities, and we can publish books. And also through the students, through the NSS volunteers or NCC volunteers, we can reach out these books wherever NCC or NSS programs are conducted. These books can be distributed. Also, the digital material can be downloaded. Plus, you can download our app, which I suggested. The NALSA app is also available on your handphone.
Thank you so much, sir.
Thank you, sir. Before we proceed to the vote of thanks, a small notice to all the participants of the technical session for presenting their paper. With the permission of the principal, the session has been extended from 2 o'clock to 2:30, and all participants are informed to join the link 5 to 10 minutes prior to the session, and the session will be conducted parallelly through breakout rooms, which have been assigned to you. Now, to the vote of thanks. Yes, sir. It has been a marvelous time listening to all our resource persons today on this one-day national virtual seminar on legal service, a tool for access to justice. I would like to extend a heartfelt thanks to all our resource persons today. Sri H. Shashidhar Shetty, sir. Thank you, sir. Professor Dr. C. Basaraj, sir. Thank you, sir. Professor Dr. C. S. Patil, sir. Thank you, sir. Professor Dr. M. R. K. Prasad. Thank you, sir. And Sri Sridhar Sethi, sir. Sridhar Prabhu, sir. Thank you. I would also like to extend my thanks to our faculty members, our principal and chairperson, Professor Dr. Suresh Vinadagaudar. Thank you, sir. Our senior faculty and former chairperson and dean, Professor Dr. V. Sudesh. Thank you, sir. Dean Faculty of Law, Professor Dr. N. Dashrath. Thank you, sir. Coordinator, ULC Legal Services Clinic, and Associate Professor Dr. Satish Gowda N. Thank you, sir. Associate Professor Dr. Jyoti Vishwanath. Thank you, ma'am. Associate Professor Dr. Chandrakanti L. Thank you, ma'am. And also our librarian, Srimati B.G. Shivkumari, ma'am. Thank you. I would also like to extend my thanks to all the dignitaries of their respective fields and capacities who have graced and attended the seminar, and all the other syndicate members and principals of other colleges. I would also like to extend my thanks to all the students, participants, and the media houses, but last but not the least, the teaching and the student coordinators who have helped make this seminar a grand success. Thank you, one and all.
Thank you, sir.